May I have your lordships? May I have your lordship's kind permission, my lords?
Yes.
Lord, application has been filed not for listing of a writ appeal arising out of orders of the Honorable Single Judge, not holding that the adjudicating authority under PMLA is quorum non juris. That is being followed in a number of cases, Lord, and the attachment orders which are confirmed are being stayed and set aside. Lordship may kindly give an early date for hearing.
Hearing of what?
Writ appeals, Lord.
Final hearing?
No, admissions, Lord. Admissions.
Admission. Oh. So 27. 27.
Oblige.
Oh. Next week. 5:10. Yes. Today. Yes. Yes.
Portions pertaining to medical admissions.
What covered? How many cases?
Direct.
How many cases? We see a bunch in your hand.
Eight cases. 8 cases. Yes.
Covered, no? You have annexed the orders.
That's what your lordship same.
Covered.
Pertaining to a medical admission.
Covered, madam?
Covered, madam.
All right. Covered. No, what? Medical ad. Medical ad. Fine. Today.
Permission of your lordships. PIL 51 of 2023. The matter is numbered in the month of August, 2nd of August. The matter is not listed yet.
Why? There must be something. You find out.
No, my
what
lord.
is this PIL about?
But this PIL about is challenging the action of the municipality in not taking action against an illegal layout which is laid in the riverland. This is been numbered.
We will see why it is not listed. Registrar Judicial will look into the matter. It should be listed. If it is numbered, you know the rule. It comes up on the next day. There has to be something. You meet him.
Yes,
yes.
I will.
The Arts Commission, it appealed number 594 of 2023. This was listed in July. And the final hearing was heard. All the arguments were heard and the seating arrangement got changed. Till that, from that time, this is not getting listed. I am representing the respondent. They have filed a frivolous writ appeal and
no. What is I mean, for what you want listing? Admission?
To dispose of this writ appeal.
No, wait. Please file an application seeking an early listing of the case. 2000, we are struggling with 2099, 98 petitions. There is no justification for hearing 2023. If there is a justification, please mention. We will consider. We don't list cases for final hearing on a mention.
This is the admission stage itself. This came up for the final hearing.
You please. It can't come up for final. Is there an order? Which order?
Yes.
Who has passed this order that at the admission stage it will be finally heard?
Because
which order date? Which is the order dated?
19/7/2023.
There is an order?
Yes, my lord. It says that.
Hey, what is the urgency? Because your client wants that it should be decided in 23 itself, right?
No, my lord.
We don't have. You please file an application for early hearing. We will consider.
Lunch motion, my lord. Medical admission covered by lordship's order. 6 matters.
Oh.
My lord,
Lunch motion?
Lunch motion, my lord. Matter pertaining to the challenge the recruitment notification pursuant to the Telangana State Judicial Cadre Service.
Tomorrow.
My lord.
Sir,
Yes.
40 persons, sir. Case 192/2020.
What final hearing?
My language is Telugu, sir. Language problem, sir.
You meet the registrar judicial. He will tell you you have to file an application for early hearing, right?
August 24th బెంచ్ మీదకి వచ్చింది సార్. డిస్కస్ చేసేసి రీకౌంటర్ ఏమని చెప్పన్నారు సార్ మీరు. రీకౌంటర్ August 30కి రీకౌంటర్ చేశాను.
రిజిస్ట్రార్ జుడిషియల్ ని అప్రోచ్ కండి. వారు మీకు సజెస్ట్ చేస్తారు ఏం చేయాలో చెప్తారు.
Call item 1 pronouncement of judgment.
For the aforementioned reasons, we concur with the view taken by the learned single judge in the impugned order dated 19/12/2007 in writ petition number 17626 of 2007. In the result, the appeal fails and hereby dismissed.
You are not the appellant, right? From your body language, we could make out that you are not the appellant. Very interesting. I was just noticing that this just exactly same. Like at the first impression, anybody will be feel like a sign.
Thank you, Chief, for the opportunity.
Next.
Item number 2,
Please, your lordship. You know, this second case is coming for the first time.
Oh,
Notice will have to go to the respondents about it.
oh. Oh, but we were wondering what is the direction according to
The
you?
direction your lordship will see at page 52, my lord, page 52.
52. This 41, right? 41.
I'm sorry, page 38, 38, I'm sorry,
38.
38.
What is
Paragraph
the
52 it is.
paragraph?
52.
Ah.
We therefore have no hesitation to set aside the memo number so and so, passed by third respondent and issue a writ of mandamus to third respondent to implement in the revenue record the various notation orders passed in favor of the petitioner and his vendors and incorporate petitioner's name in the Pahani package of Patrika of Hafizpet village in respect of extent of 7.27 guttras purchased by him and also in the official website Dharani Ma Bhumi within 4 weeks from date of receipt of a copy of the order.
No, but what we were seeing, that conclusion we sought at page 41.
Yes.
So this is for contempt of an order passed in 19303, right?
Yes.
So what does E clause say? 19303 is allowed and letter is quashed, set aside,
Yes.
and consider fresh application for grant of construction permission.
Yes.
This is the direction.
That's again a
So
THMC.
this, you are not, this thing, they are not considering your
Not
application.
considering. We went on repeatedly, my lord, making representations for implementation of the court order, my lord, they did not implement it.
No, because the direction in WP number is this only, that it is quashed and they have been directed to consider your application. Are we correct in saying
Yes,
so?
they did not consider.
Ah, yes. Third, you want to accept notice? We have not seen a person more keen in getting this thing.
There is Supreme Court
Third.
order that having those orders from the state government people except if the order.
They referred SLP, which has stated my affidavit. No orders are passed by Honorable Supreme Court. SLP has been, my lord, leave has been granted.
You have filed caveat?
No, no.
Then
Just I want to bring to this honorable court notice whether Supreme Court matters.
don't, Mr. Lose your dignity merely because principal secretary is impleaded as respondent. Don't lose your dignity as officer of the court.
Yes, I want to bring the.
No, either you file a caveat or you don't. You should have filed caveat if you are so sensitive that the court cannot issue notice to principal secretary revenue department.
Like that.
We will teach you, Mister. Don't. We don't want to start the day of the week with your stupid this thing behavior, right? Mark Lurich, we are issuing notice. You challenge this order is applicable before Supreme Court. 136.
Supreme Court directed.
You are accepting notice. Then why are you interrupting our proceeding? If you are not accepting notice, why are you interrupting? Third, on the question of admission issue, this petition has been filed for non-compliance. All right, so Mr. Senior Counsel, we will list it along with CS 14.
My lord,
List it along with records of CS 14 of
This
19,
the CS 14 land only.
CS 14 of 1958. Yes.
Before proceeding my senior counsel,
Huh?
for the respondent, if they are intended to
Caveat, you have filed a caveat?
appeal, if the writ petitioner I appeared before land single judge, I am filing, I was served the papers with respondent. He has intended to file.
He doesn't want to argue, to argue, take the trouble conceding that it's a case for admission.
All right, not
So
that.
this is what is happening in both the cases. In contempt also he stood up. Here also you are standing up. What can be? We would have asked him some questions. Have you filed caveat?
Small submission, my lord, I believe.
Have you filed a caveat?
No.
Then what right do you have? Tell us in law as an officer of the court to, when the appeal is listed for admission, you will not permit the senior counsel to address the court and interrupt. What right? Please tell us which rule.
I apologize for that.
No apology.
But one submission.
We are not interested in apologies, but we are asking you which provision of the rule, this rule, High Court's rule permit that when the case is filed, you will interrupt.
Not interruption, if I am created such impression, my lord, I may be pardoned to say, only one submission, because three expeditions, common order is passed. If they intended to file appeals in the second also, it may be taken up along with that. That is only simple request, instead of, that's what I am praying you last. Otherwise, there is no need to interrupt. Let me proceed if it is so, my lord, it is convenient
Sit
for
down.
my.
If you have not filed a caveat, sit down. If you have not filed a caveat, we request you to sit down, please. If you have not filed a caveat. If you have filed a caveat, then you have right to oppose admission, oppose the prayer for interim relief once he is heard. But no law permits you to interrupt when the case is, you will not permit the senior counsel to address us and interfere.
I'm sorry, I'm listening.
Yes. How, Mr.
There are three.
No, but see, Mr. The one difficulty, Mr. These people don't, understand anything. They interrupt his, like this only the day has begun on a wrong note. But what to do? Let us get back to the track. The query which we had was that this thing you had made a challenge to demand notices issued on 23/10/2013 and 10/12/2013, right? But you did not make a challenge?
I am the respondent in the writ petition.
Oh.
The relief granted is go to the CGRF. CGRF is not a party and already CGRF dismissed the claim.
Claim.
And appeal by the before the ombudsman, that was also dismissed,
Yes, and that order was not challenged.
not challenged.
And despite that, the court said that you go to before consumer.
Not go, directing the ombudsman and CGRF to decide,
They will
even without making them as a party.
heard on the question of admission. Heard on the question of admission. Mark is present. Operation shall remain state. You will accept notice? At this stage, Mr. So and so accepts notice on behalf of respondents and praise warrant is granted. How much time?
2 weeks.
2 weeks time to enable him to file objections to IA number 1 of 23. Yes.
I beg to appear on Lakshmikant Mehta. There is a case, my lord, where the writ appeal is filed against by a third party, my lord, who is agreed
What
by
has
the order.
happened? He is directed, see, anybody can, you may be the owner, right? You have come here saying that I am the owner of the property and nobody can present a deed for registration.
But I am a Milord. I am the owner by a.
No, how do we, 1 minute, how do we decide the question of title in a writ petition? Two constitution benches decision of Supreme Court, twice, 2 benches have said, Constitution bench, that the question of title cannot be gone into writ.
That's true.
Writ appeal and writ petition. How can we record a finding that you are the owner and therefore this
Well,
order,
there is a
you take recourse to AIR 63 Supreme Court is the case law, which
Yes,
says
well,
that if you are not a party, you challenge this thing, you challenge the order in a separate
No, I am on a
independent
different
proceeding,
footing, my lord.
that order does not bind you.
Milord, I am on a
You tell.
different footing, Milord. There is subsection of material fact. That is
Were you respondent in the writ petition?
no, I was not made a party, man.
Then you,
And I am agreed by that order, my lord. I am agreed by the order. And therefore, Milord, the Lordship will kindly appreciate, Milord. There is a comprehensive civil suit for declaration pending.
whether you file a suit, whatever
No,
suit
suit is pending, Milord. That was not disclosed.
file an injunction.
No, Milord, for the same property, Milord, earlier this honorable division bench, Lordship will kindly produce the order, Milord, as they remanded the matter. Same property I paid 245. Same property, same parties.
Remanded.
245. Because there is suppression of material fact and we are not
No.
deliberately not.
Mr. Anybody, see, Mr. How can you get, sir, a blanket sort of an injunction that nobody should present any document relating to this?
Well,
And
even-
how can court this issue
Even that also, Milord, this sub-register is written on the ground. What has happened, Milord, Lordship will give me only, Milord, 2 minutes time for my satisfaction, Milord. What has happened, Milord, I am the owner by virtue of registered sale deed executed by the owner.
You may be.
Now, Milord, they created an unregistered sale deed as a lien document and then created a sale deed
You
for.
raise an objection. Now you have learned that the court has directed you raise an objection. To that extent, we will modify that before registration
because-
of this document, your objection shall also be heard by
No,
the
Milord,
registrar.
why? The sale deed is already executed, Milord. By virtue of the interim order passed by the honorable court. So final order, by.
Yes.
This what has happened, Milord. They fabricated a unregistered sale deed on a back date. And that was treated as a lien document, then presented a sale deed bill. Now the sub-register took an objection.
How can the sale deed be challenged in a writ appeal? That is a different thing. How can he says that in purpose of the interim order passed by the single judge, it be related. How can we challenge the sale deed in a writ appeal?
When earlier order covered the same survey number, same land, same parties, man. Except for the petitioner.
How can you challenge the?
Because here, this is Milord, a mischief play.
1 minute.
Please follow. How can you challenge the sale deed in a writ appeal?
I'm not, I find the writ appeal.
You see,
In every party, I'm seeking the leave also to file a writ appeal.
No, basically you are challenging registration of sale deed in favor of the writ petitioner
No,
in
Milord.
this writ appeal.
Milord,
You want that should be set aside. We
Milord,
cannot, SP Anand says we cannot set aside.
The writ petitioner has sought an order.
Mr. SP Anand versus Union of India says
Yes,
that
Milord, but I
we cannot set aside a registered sale deed in a writ petition.
Milord, we're not asking that a declaration like a civil court, Milord. What I am respectfully submitting is that, Milord, that I was aggrieved by this order passed because that direction was given, Milord, to
You have
register
the
the sale
liberty
deed.
to challenge this order in you know 63 Supreme Court. 63 Supreme Court. You know
Yeah,
that if a
earlier-
party, a person is,
Milord,
yes,
subject-
Mr. Mr. Srinivas, what is that 63 Supreme Court 5 judge bench decision which says that if a person is not a party, he can file a separate writ petition. 63. Huh?
Be able to
Ah.
it is looking for.
Ah.
Special judgment followed by-
Where is that? Please supply.
The other day, Milord, my lords of reserve, writ bill 697 of 2023, disputed questions of title, Milord, has to be good. Civil court, they have to relegate to
That's
civil
not
court.
disputed. He say himself saying that he is not challenging sale deed.
Milord,
We don't know. You file a fresh petition, Mr.
No,
If
my-
you are aggrieved by this order.
Milord,
This order does not bind you in any way because you are not a party to this.
no, but it has been registered by the sub-register, Milord, by virtue of the direction. Now, a sale deed is created, is reflected in the encumbrance certificate.
Legal judgment of Assam to 2003, 4 Andhra legal decision, PID, page 449.
What is it that a person not a party can file?
You can file a separate writ to cancel the judgment.
This is your remedy. Division bench says so. 2003 volume 4 ALD 449. So repeatedly these appeals are coming before us for IA
No,
for
but-
permission. Then with I
Sir, in the practice
yesterday
of High
it struck
Court
to us while going through that your remedy lies somewhere else.
No, because
Please
I-
see, Mr. You are correct. But what we are not holding that on merits you are wrong. But what we only pointing out, there must be a reference to Supreme Court decision in this.
No, Milord,
I'm sure.
it is a practice in our High Court, Milord.
They-
That every party can prefer
Division
the
bench.
leave by.
Division bench. Of you see 2003 volume
No,
4
this
ALD.
is an option, Milord. Otherwise, leave can be granted by the division board.
We don't want to grant leave. Anybody can file a document seeking registration. The registering authority doesn't decide the question of title. The prima facie satisfied itself. But how can we give a
Because-
declaration that you are the owner of title now? 1 minute. You are what we will have to decide in this writ appeal. Number 1, to grant appeal. Then to hold that you are the owner of the property. Third, say that action of registration of registering authorities have been issued void. Then fourth is to quash that sale deed. All this is
The only thought I am saying, Milord, that non-disclosure of true facts, well. All these points have been disclosed. That is a civil suit pending where is a petition to a party.
this
That is
execution
not
of
disclosed in the written
execution of the sale deed will be subject to outcome of the doctrine of lis pendens. That we can say. Doctrine of lis pendens applies. The sale deed which has been executed shall be subject to outcome of the civil suit which you have filed, seeking the relief of declaration of title, right?
Because
You
earlier
don't
already,
use-
Milord, there is a subsisting order. In respect of the same property, same survey number, my lord.
Right. This is doctrine of lis pendens. You know it very well. What I'm-
Of course, my
You
lord.
know it very
No,
well.
no, because I'm repeatedly.
We are not non-suiting
Sorry,
you in
Mr.
any listing on merits. We are not non-suiting you on merits
know,
on
but,
any ground. We are just telling you.
Repeatedly, I'm taking the submission because there is already a direction given to the sub-petitioner. In respect to the same property, same survey number, same parties.
What direction? That sale deed is cancelled.
Not which I pointed out at page 245, Milord.
What
Order
is
was
the direction?
satisfied. And Milord, the matter was to be, it was
No,
refunded back to
same
the
thing, Mr.
single bench.
Instead of
251 Lord Supreme Court.
no, why we will say that this division bench direction does not bind us because it does not take note of the previous division bench decision of 2003 volume 4 ALD 449 which was binding on this division bench. And in substance the same thing, Mr. Sale deed has not been quashed. Sale deed has been registered. It has been said that sale deed shall be subject to outcome of writ petition. Here there is a civil suit. All we are saying is sale deed will be subject to decision of civil suit. No difference. We are not taking any contrary view.
No, there Milord, we are given a party to.
So far as your this thing similar order should be passed. It is not binding on us because
No, that's true, Milord. I
because,
don't doubt that.
it does not
I
take
am-
note
I am
of
only-
earlier division bench decision which we are referring to.
I mean, if it is
2003.
remanded and get a chance to Milord bring to the notice of the honorable single bench, the true facts.
You
are-
file review of the order. If you whatever remedy, according to us, the remedy lies. We don't know what should you do. We have stopped doing this like some while ago, decades ago. Yes,
Lord Supreme Grant has the liberty to file a fresh writ petition.
right. That's what
Following the division bench.
2003 volume 4. Hey, what is this, Mr.? Every time you run to the library, right? ALD is not there. Nothing is there. 2003 volume 4A, the library he has gone, right? They must be sleeping right now at 11 o'clock. They will have to be woke up, offered a cup of tea, then they will find it. What books have you kept here? All useless books, right? At least 15 years ALD, you get it here, mister. 15 years ALD till 23, it should be here.
Earlier Supreme Court
Before
judgment
130.
also there. Yeah, 1963 Supreme Court 1909.
Ah,
At the
that's
same
what.
time.
Yes, 63 Supreme Court. I told you, 1309. 63 Supreme Court.
1909.
You know it, Mr. Senior Counsel. That's what we told 63 Supreme Court.
No, in the practice, we obtain the sleeve and then we prefer it in our High Court.
But that's what it can't be. It is that is the main source. See, Mr. Our staff, see what 2003. We have in your presence. We have told you that is Mr. Before 130, Mr. C. Before 130, all 15 years should be here. Keep it here. Don't, I mean, whenever a book is required, he will run. They must be sleeping, right? They must be sleeping in the library. They will have to be woken up, given a cup of tea, then they will get up. This intra-court appeal has been filed against an order dated 20th September 2021, passed in writ petition number 21688 part them to send from 2000 till 23, all ALD here.
Page 1909. Okay.
Yes, 190. Yes, correct. This is division bench in 2000. This is it, madam. Write the name. And Supreme Court also you will get the name. All right. Thank you. Yes, next.
Next matter of same order.
Same.
Item 5.
All right. Same order. Item 5.
Obliged. Obliged.
Yes.
Please, madam. The petitioner is running a dairy farm, my lord, respondent number 10.
So what happens to section 31?
I'll
Appeal.
My grievance.
File an appeal.
And my grievance is on 2 counts. Number 1, violation of principles of
There is
natural
nothing, no violation. Notice was given to you on 11/8/2023.
Your lordship,
And to remedy the defect, you didn't do it. And thereafter the order has been passed. This is all the grounds can be urged in appeal.
yes. Your lordship kindly see that notice.
Whether or not the appeal lies under section 31.
Yes, appeal. May I submit
Fine.
this? Your lordship kindly see that
It is
notice
all
is issued under
listed.
different act. Impugned order is passed under different act. Kindly appeal.
Air Prevention Act.
Yes. Impugned order is passed under Air Prevention Act.
Huh?
Notice is issued on water prevention. Kindly.
These people are like callous, no, they want to help you. There we have no hesitation in saying that their officers are mixed up with you and they want to help you in getting an order from the court. They are callous people.
Then,
They don't decide the representation,
my,
right?
my,
They deliberately do it so that you get an order of stay from the court.
lordship, I kindly appreciate.
Deliberately do.
Kindly
We have-
appreciate this.
And in appropriate case, we will, this thing we have come across, pollution control board, thoroughly useless people. They don't this thing. They don't decide the representation. They contribute to the pending litigation in the High Court. Half of the petitions are filed because people make complaint. They don't decide. And this is, they may have been given. This all contention can be urged. You understand, right?
Yes, I understand.
I understand that what is you means your client understand what is the violation.
Yes.
So we are writing, they will write Space Air Pollution Act, they can write. They are capable of writing
My,
violation of Space Pollution Control Act. They can write anything to help you. But we won't
I agree.
file an appeal.
Kindly see this, my lord. This order was implemented even before passing the order.
It should happen, right?
I have 53 animals. my
Air
lord, which were
Prevention
need to-
Act.
This order is already implemented even before passing the order.
Yes.
Kindly appreciate this, my lord.
So there is an appellate forum. All these otherwise,
No,
we
no,
should have how many,
Yes.
I think more than 500 judges in the High Court, right? And all this thing provision should be repealed. So
I
every this
give the
thing,
appeal, my lord.
he should notice, then you directly come to the High Court, file a writ petition, everything. Mutation entry, direction to the registrar to register a sale deed, closure of industry. Thankfully for in this occasion, they have acted. Otherwise, they keep on, he knows that they don't take action. Correct? Huh?
Lord,
We have made them issue a timeline
my lord.
for decision of complaint.
My,
Ah.
kindly see this,
And
my
they
lord.
have told us that if they or guidelines are not adhered to,
Appeal, my lord. Your lordship says, my lord, 30
Air
days is the
Prevention Act.
limitation. Appeal, my lord, you will.
what? Did not sleep or what?
my lord, kindly see.
Disclosure of there is a regulatory between yes, on the people. This needs not like that. This people stop entertaining petition. What is the use of making this? It's all they want to come here and get stay 25 years. Petition will remain pending.
I'll go to appeal, my lord. Kindly see this. Meanwhile, what happened?
Go appeal.
Your lordship, kindly see this, my lord. My lord, appeal, my lord, 30 days is the limitation, my lord. Now they implemented the order even before, my lord, passing the impugned order. Now, my lord, I have 50 animals, my lord. I need to take care of their food, shelter, water. I need to relocate them even if I want to implement the order. My lord, these are animals, my lord, food, shelter, everything.
They have fundamental rights under the Indian
All I'm
Constitution.
asking is 30 days, at least I should have a breathing period to go for an appeal. They implemented even before passing the order. Just suspend it for 30 days, my
No,
lord.
no, if, what is like, I mean, this is a forum of grant of stay, right?
Now, kindly see the impugned
You have
order.
come here only for this, to get a stay and keep the
No.
petition pending
Your
for
last-
31 years. No,
Your
no,
lordship may dispose of it.
for 25 years. We will not do it.
The problem is this, my lord, they cut the power, my lord. Animals are there, my lord. I can't feed them. I can't give water to them, my lord. I can't relocate because 50 animals, it takes some time.
They are very generous people. Make an application to them. I want to feed the animal. They are
already
not inhuman
implemented the
people.
order.
They will permit you to feed the animal. Right? Huh?
To that extent,
See,
your
there
lordship,
is
may- to
fighting.
that extent, your lordship may observe, my lord. That's all my
There is
grievance.
nothing observed. In this writ petition form, the Mark heard. Withdrawal has filed a memo seeking leave of the court to withdraw the petition. The aforesaid memo is taken on record. The petition is dismissed as withdrawn. No opposition?
No.
Sick.
Blessed.
Petitioner counsel.
Same order. And no objection, Mr. Yes. Hmm.
Last time I passed on the synopsis along with judgments.
What is the 2003 4 ALD page?
249.
Yes.
I passed on the synopsis, my lord. It's only issue of the change in law, my lord, by the Honorable Supreme Court, overruling the division bench judgment of this Honorable Court.
At the end of motion hearing, we will take it up. At the end of motion, just after 5-10 minutes, so that others do not wait.
Yes.
Yes. Next. 12. Huh?
Short password will
Hey, what password, madam? This amendment to the prayer amendment.
My senior counsel engaged at third fourth will.
Hey, this is also court. What do you think? Not a court. This is a this thing amendment of the petition. You don't know even, madam. Yes, amendment. So we will allow it that they even don't even know what is the amendment. See, heard on IA 1 of 2023, taking into account the saying that I don't know.
Just my
Then
senior.
why you are an enrolled advocate, right? You come to the court.
Okay.
You have never incorporated an amendment in your life. Huh? You have done it, no? Then you should know that I would do it within this much of time, 3 weeks, 3 days or 1 week, whatever. Yes. Yes, 15.
May I please your lordship? Lord, on the last occasion, lordship directed the respondents to get information regarding the number of existing vacancies in the state of Telangana. Lord, petitioner is working in state of Andhra Pradesh, my lord. She's
Hey,
also,
why don't you file counter? And how can you reject her representation on the ground that there is no provision? That can't be done.
Finally taken 2 weeks time, not.
Hey, what 2 weeks, mister?
in fact, it is covered, my lord, similar facts and circumstances where,
No, but there is no, you will have to show us what is the, where is the vacancy. There can't be similar, right?
my lord, district
You are
collector,
saying this is, you are wrong in making a submission, it's similar. In that case, petitioner's eligibility was not disputed. Secondly, there were vacancies. That's why.
lordship may see page number 87, district collector himself said that there are clear existing vacancies, my lord.
Where is that?
Page number 87, my lord.
87. Hyderabad district, 19 section. Oh,
There are 19.
Mister. What we will do is we will ask them to decide your representation in the light of communication sent by this.
In fact, they issued relieving orders,
District
my lord.
collector.
They have rejected my representation. They have,
We are setting aside that order. Do you understand?
Very well.
They have rejected it not on the ground that there is no vacancy. They have rejected it on the ground that there is no provision.
yes,
That why to keep it is you did you see what is he saying? 2 weeks time. There is no guarantee that they will file within 2 weeks.
obliged.
He doesn't know what is the case. What is the case of the petitioner? How can you reject it on the ground that this thing?
Petitioner husband working in the central government, my lord, it's railways.
Mister, tell us, justify your action of rejecting the representation that there is no provision. You can't do it.
The proposals, my lord.
You cannot behave like a private litigant to obstruct the path of justice. This is what the Supreme Court had to say. And in a contempt case, when we were about to issue notice to some of the IS officer, this thing stood up. This is policy, right?
Also,
How can
in the data.
this is basically page.
Lord, page 43.
43 to 57 is the relevant order, my lord. Order of this honorable court, similar facts and circumstances were dealt, my lord.
No, they can't reject it on the ground that there's no provision. No, where is that? Please find out. This intra-court appeal emanates from an order. No, not this writ petition. Mark the presence. This writ petition. Delete. Next.
Please.
Yes.
Ashok, on the earlier occasion method, GP has fixed a time to file a two judgments method.
Yes. Similar provision has been affected.
Yes.
Where? Have you gone through?
We have gone through method. I would like to submit two issues method. For the first judgment method,
Where is the judgment? Mr. We don't have. When have you filed?
Well, it was filed on 21/9.
When? SR number, etc. You have something? We don't have it.
Right now, I don't have the exact number,
Then-
that has been filed by the clerk on.
That's the problem, Mr. Not filed. Learned counsel for the petitioner once again, respondent once again prays for adjournment in order to enable him to place on record the copy of the
interim statement.
it, it does not come as a matter of course, right?
Okay.
You have said interim stay be granted. This is like this usual thing, right? Now we are entitled to pass an order.
Yes.
Right?
Page 85 method.
Where is that judgment? Rahul Reddy, you know him or don't know? Yes.
Page 85 method. In the similar circumstances, this honorable court,
We don't want to give. Interim order has no binding precedent.
in the similar circumstances, method, to lordships.
Yes.
This is in fact the case which the GP was also relying in the compilation method.
All right. This has been made, this demand has been made in pursuance of an amendment made to section 13(1) of
Yes, my lord.
Fine. The impugned demand heard on the question of stay, the impugned casually standing up, don't know what is. That means your people who are assisting you are not doing their job. Yes. Yes.
My lords, in this matter, your lordships on the last occasion passed an conditional order directing me to produce the original certificates within 1 week.
Submitted.
I complied.
Yes. Now what survives?
Nothing survives.
Oh, nothing. That we need to say. In this rate petition, mark the presence. In this rate petition, the petitioner inter alia has prayed for the following relief. Yes.
Counter filed. Counter filed.
Pleadings are complete.
Yes, ma'am.
Private respondent, we filed out.
Any you want to file reply?
Yes, my lordship. And my lordship.
Petition is admitted for hearing. Learned counsel for petitioner praise fund is granted.
The last occasion, your lordship
Amendment.
directed.
Will amendment we will allow. Yes. Heard on IA number so and so what 2 of 23 taking into account the nature of proposed amendment and for the reasons assigned therein same is allowed.
On the similar situation, not another petition is pending, my lord. Same, for the same relief, not another petition also is pending, my lord.
But you can make an application for linking, right? Yes.
Much over.
Yes. Nothing survives now. What is there? It's all concluded. You must have read in live law, right? That the guidelines, insofar as it prohibit this thing made of plaster of Paris were challenged before the learned single judge of Madras High Court. He said that no, you can make plaster of Paris idols, but immersion shall not be permitted. Right? Against that order, division bench set aside, SLP dismissed.
But so far as our grievance is concerned, my lord,
You cannot. You want that we should be allowed to make plaster of Paris idols.
that is only, my lord, my concern. And in
So
fact,
that is what we are telling you. There are 2 judgments against you, Mr. Before you argue, you should know and you should be realistic with ground realities. We told you, if you read the live law, if you follow it, you should know that division bench of Madras High Court on similar issue has been upheld by Supreme Court, SLP dismissed. So there is no scope of argument further. And secondly, Bombay High Court has taken a similar view, upholding the validity of the guideline. Bombay division bench of Bombay High Court has followed the order of NGT. Subject to that, whatever you have to say, you may argue. And Mr. This thing, you had told us that there will be no immersion of idols in Hussain Sagar. How that is, I mean, is it taking place? First thing, and you must take all steps to stop it. Like this, in Times of India, probably today, go to library again, Times of India. They are sleeping, wake them up. In Times of India today edition, it is reported it is for you to see, examine, because this thing that despite the ban by this court, you are permitting immersion of idols in Hussain Sagar Lake. This can't be tolerated.
May I please respect?
No, whatever it is, Mr. Prasad, like, let us be realistic. I mean, I also passed through the same way. I have come to the court today from that very way. I have seen two cranes. What cranes are doing? You are not cleaning the garbage.
We are
They
bound.
are obviously, they have been, I think so. Though I haven't seen, but probably huge Ganesh idols, they want to, cranes have been this thing so that it can be immersed.
We are bound by the Lord's order. There is no.
No,
We are
but
bound.
there is already, you cannot permit immersion in Hussain Sagar Lake.
What the division bench earlier has said, not from the rear side of the lake, the idols can be immersed and POP idols can be immersed only in baby pond.
No, we will, Mr. You know, right? Why you keep the file there? Give that. See, Mr. There is an SLP order which we were given in undertaking.
For that year,
In this writ
1 minute. Give the file. File. You give the whole thing. There is. SLP, Mr.
yes, sir.
You have given an undertaking before the Supreme Court.
Yes,
Solicitor General on your behalf,
yes, sir.
right?
Yes,
Where is the order?
but it,
Civil Appeal 6296.
yes, may I read the order? The undertaking was.
Huh?
May I read the undertaking part here?
Hmm.
Which was part of the recording.
Yes, we have got this SLP.
SLP.
21921, right?
May I read the order from it?
1 minute. Rahul Reddy. Ganesh immersion. We had prepared this thing. Give the printout if you have. You had not prepared any print this thing. Did you prepare any synopsis on this? No. So then give Madras High Court. Give Madras High Court. Yes.
May I read the order of the Supreme Court where the undertaking we are also referring to? Last two paragraphs.
You know what is the undertaking given by you, right?
Yes.
So you cannot permit.
But one aspect may I place it before my lord.
And this is perhaps this thing, a wider this thing.
Yes.
And this order has been upheld by Supreme Court SLP. We'll get that printout.
Yes, but the orders have been upheld by the Honorable Supreme
No, that's correct. But see, we were asking you about immersion of the idols in Hussain Sagar. But it says that plaster of Paris immersion itself, you will.
One aspect I'll place in factual aspect.
So let us hear in what you have to say. What is your petition, Mr. We'll hear you.
So far as my case is concerned, Millard, it is not.
What WP 16939? Which is your petition?
Yes, but one submission before Millard.
Which petition?
My case is 19639 of 2000.
1963. Oh. 1963. Yes. What is the prayer? The plaster of Paris idols
Revised guidelines
are illegal, arbitrary.
totally banning, Millard. It is only
yes.
banning. I am not seeking for immersion and all that. And in fact, Millard, as an interim order, Millard, you Lordship, Millard, directed them, you Lordship, kindly see the interim order passed by this honorable court.
There is no question of interim order now. This is Mr. Prohibiting manufacture of the plaster of Paris idols, division bench of, that's what we are telling, Mr. You have to be realistic, right? You have to see the order passed by, order which has been affirmed by Supreme Court, and therefore it is prima facie binding on us. You have to go to Supreme Court. We can't at our this thing. We told you in the beginning itself. Learned single judge took the view. Plaster of Paris can be made, but it cannot be permitted to be immersed. To be immersed. Division bench set aside that order passed by single judge of Madras High Court. The matter has been, the SLP has been dismissed, upheld by Supreme Court, and we have got all these orders here. Right, Chief Justice, Honorable Chief Justice, Honorable Justice JB, 3-judge bench has dismissed SLP. And then there are 2 division bench Bombay judgments of two division bench judgments of Bombay High Court on this issue. And they are undertaking before the Supreme Court that they will not permit this thing. Yes. So you have a right to make, that is fundamental right.
No, Your Lordship, I have those judgments, I'll go through them, so far as.
No, this is listed today for orders, Mr. With the understanding, last time,
No.
if we remember, you made faces. We told that you are making face, same case, right? We remember. You knew that it will be taken up for final hearing today.
On Friday, they have served a counter.
Nothing, no counter. You argue this thing, you are challenging the guidelines. What is Article 1921 300A of the Constitution, and this is violative. This is your submission. Fine. You have a right to make a idol of plaster of Paris. This is your submission.
But that is what Your Lordship pointed out certain judgments.
We did not point. No, it's your duty, Mr. It is not the duty of the court to point out judgment to you. It's not. We have not accepted anybody's brief. We have to be well informed, and so that we can, our judgment is well considered. That what we have done our homework. That doesn't mean that you will seek adjournment on this ground.
But I'm not.
That court is citing judgment. Because we don't. You challenge it in SLP. Yes.
My endeavor, Millard, is twofold, Millard. One, they have
submissions you make, Mr. We know, understand the fact.
I make submissions because they file counter. But I need to reply the counter which they have filed it, Millard. That is, they have served on Friday, Millard. But though Your Lordship directed on the earlier occasions itself, they have served only on Friday evening, Millard, and that we got it today, Millard. Therefore, Millard, I need to reply to that, Millard. That is on one count, because otherwise they would say that it is not replied. Therefore, we have to go by that counter.
We will grant you 3 months time to file rejoinder, but the interim order will be passed today. Yes.
But interim
3 months.
So far as
your case is concerned, you are praying for adjournment. You have argued. Next case, who is the other one?
The other matter was withdrawn.
1 minute, huh?
The other connected matter was withdrawn by the Learned Council.
Withdrawn?
28 WP 28931 was withdrawn.
28
931 of 2022 was withdrawn.
No. This there are 2 cases or only 1 case.
The second case was withdrawn, Millard, on the last case. It was withdrawn because it was for only
193
28931 was withdrawn, Millard, on the last.
Where is the immersion?
28, Millard.
28. So yes, you don't permit, Mr. This we are passing an order for the state government. You are not.
That's what I am bringing to your Lordship notice. There is
you are, Mr. What bringing notice? You are praying for time. We are granting you 3 months time.
No, I am only bringing that there is already a direction to them, not to immerse. That is what I am trying to bring to. Your Lordship directed in this order itself, there is a direction.
Which order?
Your Lordship interim order, there is a direction. Your Lordship kindly see page 7, Millard. Page 7. Page 7 of the interim order passed by this honorable court. Thus we find, among other directions, state respondent were directed not to allow immersion of POP.
Which order? Mr. Which order? Page 7.
Interim 21/7/2022 order passed by Your Lordship, Millard.
21/7/22.
22 will.
No, you are not concerned with immersion.
No, no, I'm not concerned.
Then why are you bothered? It is between us and him, and this lake is not meant for you.
Yes.
It is for generations, not polluting by making plaster of Paris. And you don't say anything because we are granting you time.
That's I.
Right, Doc.
The respondent number 7,
Mister, you are bound by your this thing undertaking.
Sir, one submission.
Nothing.
Leave it.
We are passing an order.
May I submit, my lord?
One aspect I want to place it before my.
You want to immerse plaster of Paris island?
No.
Then we are passing an order, right? There is nothing to argue.
I filed IA-1 of 2023, my lord.
No, you fight out your own battle, mister. We don't need your assistance for protection of environment. You fight out, if you want any independent relief, you file the petition. We are already taking care.
Already I filed contempt case, my lord, for the last year violations, my lord. This year also, my lord, the police commissioner, my lord, yesterday visited this tank band side, my lord. He himself is provoking.
Maybe, mister, this is like, I mean, stalling the proceeding of the court, like saying something orally, then he, without notice to him, you filed it. Who are you?
I am intervener in this.
We don't want to permit intervention at this stage. We are passing an order and we will see to it that it is complied. We don't want to this thing, mister, intervene, and then you are saying something or for your personal knowledge, he will ask time, then the matter will be adjourned. This is the whole game, right? Seeking an adjournment. You are saying something on oral instructions. Have you given him anything in writing?
Yes, I served copy.
Writing?
Yes, IA-1 I have served.
So then he is entitled to respond to that. We will grant him time to file reply.
One aspect I wanted to place.
This all, Mr. It's only because of you don't respond to us in time. That's why petitioners are praying for time. What can be done? He also knows. He knows that there is nothing in his case, but we can't. This.
GHMC responded.
1 minute. In this writ petition, the petitioner it is pertinent to
Taken by the GHMC.
Whatever, you have to file a report also. This thing, Mr. Harendra Prasad shall file. You get the copy, madam. Please type. We are, Mr. Prasad, you be here, we will give you a copy unofficially, just as he types, so that you can communicate. Do it just now, madam, and give a printout, so that we supply you a copy. It will be signed in due course, so that you can communicate.
I will.
Be supplied to Mr. Harendra Prasad immediately to enable him to communicate the order to the concerned authorities.
Yes.
Huh? Yes. You just type. Yes.
May I please the lordship?
Yes.
The matter coming up for interim relief consideration,
Huh?
that the matter came up for consideration before the lordships today to grant interim relief. May I pass on this, my lord? Lordships have granted interim orders in the identical matters, granting
Where?
status quo. May I pass? On 19 and
How many cases you have?
Saturday I have filed another case. This was filed on 11. And tomorrow it's one more matter coming.
No, but you see, what is the interim relief?
Interim prayer, my lord, I sought the section 97 to be suspended, and alternatively I sought a prayer, my lord, to suspend the impugned.
Say that we will not suspend.
Lordship may grant status quo, because lordships have observed on the 19th, when the matter, similar matter came up, granted status quo, my lord, I am
No, no, but you are this thing, if this prayer we will reject.
may I make one
Stay of Article 371D, this we will
Lordship may
reject.
kindly see last 5 lines of my alternative prayer also.
Alternative prayer we will grant, that we will reject your prayer for stay.
I'm not
Provision of this thing, all of you must, this thing, Mr. Know that a provision of law cannot be stayed like, just like mere for your wish.
Alternative prayer, lordship may kindly consider.
Admitted for hearing, heard on IA number, heard on the prayer for interim relief. You should study all this, mister. You should be aware that you should tell the court that yes, sir, provision of law cannot be stayed.
Statute cannot be suspended at right, my lord, but
No,
because
not as a matter of, it can't be.
here which is brought as a consequential, my lord, I sought that prayer. That is my
No, very casually people seek stay of statutory provision in Hyderabad. That is what I have learned. And that's why we have written so many judgments and given, because you will not cite it. You will not read it, you will not cite it. So we have done it so for ourselves. Note down, Mr. the order.
I'm sorry, my lord.
Yes.
Deeply obliged.
Please,
Huh?
brief synopsis.
Brief synopsis. All right, we'll take it up. Just there is one motion, 3 commercial appeals. Thereafter we take it up, right? Yes. That 9 to 11.
I have already passed on the synopsis, a few list of dates and few list of dates are there.
Synopsis.
One synopsis given by me, one synopsis given by my friend. Both are.
It begins like description of event.
Yes, description of event.
Yes.
The parties had entered into a development agreement on 23/3/2006. There is no dispute about entering into development agreement. Respondents are the owners of the land and petitioner is the developer.
But what is that AIR 63 Supreme Court 1909? Gee, the person, not the party. 1909. 63 not. Double 40. Yes.
Will enter into development agreement on 23/3/2006. There is no dispute about it. Then disputes arose between the parties on 23/11/2006. Respondent invoked an arbitration and tribunal was constituted 23/11/2016, comprising of 3 arbitrations. 28/7/2017, because in view of the law of the division bench at that point of time, the respondent themselves were invoked arbitration have withdrawn it on 28/9/2017. They withdrew the arbitration. Then on 9/9/2019, they filed a suit for identical reviews before a competent civil court. But by that time, after we entered appearance, there was a change in law. The division bench judgment was overruled by the Honorable Supreme Court in Deccan paper. Therefore, in view of the dispute being arbitrable in nature, an application was filed by the petitioner under Section 8 of the Arbitration Act, and that has been dismissed by the commercial court, agreed by which happened. Now, the learned judge takes note of the change in law, the Deccan paper bills, but only on the ground that one of the grounds is saying that I have not appointed an arbitrator in Section 8, nominated as arbiter in Section 8. Let me application dismissed. So, therefore, my 2 submissions. One are the legal question. As on because of the law prevailing on that day, the respondent who had invoked arbitration voluntarily withdrew it because it was the law on that day. And subsequently, in view of the law change of law, I had to file Section 8 application. One of the arguments is that can there be an estoppel against me? My submission is there cannot be an estoppel against the law. The law enunciated by the Honorable Supreme Court is binding on all of us, my lord. Because on that day they said it's a dispute which is arbitrable in nature. Therefore, my lord, I had filed a Section 8 application. I'm going to understand this, my lord, your lordship may take the judgment in the Deccan paper, which starts at page number 12. Page number 12, it starts.
Yes.
My lord, the contentions were raised in, the identical contention was raised, my lord, in paragraph 3 and 5 at page number 26 and 27. Paragraph 3 and paragraph 5 at page 26 and 7. Similar contention were raised. Then with page 28, para 8, the Honorable Supreme Court held in with regard to
What, para 3?
the para 3 and para 5 at page 26 are contentions, my lord. Identical contention raised there also. I'm saying, my lord, after bringing to your lordship's notice about this contention, then page 28, para 8, my lord. Page 28, para 8 was with regard to section 8 observations. We are also inclined to accept so-and-so argument on section 8 of the Act in view of the sum of the recent judgment on section 8 of the 2015 Amendment Act. See so-and-so, so-and-so, so-and-so. It is enough to state that there is a sea change between section 8 of 1996 Act and section 20 of the Arbitration Act, as has been held in para 1721 of Abitur. Post-amendment, it is clear that the judicial authority before which an action is brought shall, if the other conditions of section 8 are met, refer the parties to arbitration unless it finds that prima facie no valid arbitration exists, as has been held here in the present of the finding. So in this case also, there is no dispute about the existence. Now the crucial issue of whether it's arbitrable or not has been dealt in para 9, not page 29. The division judgment was considered. This brings to the interesting argument of as to the applicability of 31 of special impact and the High Court judgment in para 9 at page 29. The division bench judgment of AP High Court.
Yes.
So it's that's what I didn't. Then, my lord, after section 31 was extracted, then referring to section 31, a division bench of the High Court in Alliance Developers held as under section 31(2) of the Special Fact, the legislature conferred the power on the court to send a copy of the cancelled decree to the officer whose office the instrument has been so registered, and such officer shall note on the copy of the instrument contained in his books in the fact of cancel is evident from the provisions under section 31(2) that the power of nullifying the effect of registration is conferred only on the court. In the judgment in Buzalens, the Honorable Supreme Court held a right in line with right external against the world at large. Then what entire extract has been done here. The Lordship may come to page 30, para 10, points for consideration before the Honorable Supreme Court. It is now for us to examine whether a further exception can be carved out on base of Buzalens on the footing of High Court judgment in Alien Developers. In order to examine the correctness of Alien's developers, it is necessary to so and so. The correctness of Alien developers was considered. Then your Lordship may come to para number 22, my lord, after considering all other judgments. Para number 22 at page number 38, my lord. Well, let us see whether section 31 makes any difference to this position in law. According to judgment in Alien Developers, the moment a registered instrument is cancelled, the effect to being or to remove it from the public register, the adjudicative effect of the court would make it judgment in them. Further, only a competent court is empowered to send cancellation decree of the officer concerned. Note to the effect such cancellation and note on the copy of the instrument contained in books, the facts of the cancellation. Both reasons are incorrect. An action that is started under section 31 cannot be said to be in personam when an unregistered instrument is cancelled and rem when a registered instrument is cancelled. The suit that is filed for cancellation cannot be in personam only for the unregistered instruments by virtue of the fact that the decree for cancellation does not involve its being sent to a registration office. A ministerial action which is subsequent decree being passed. In fact, in Gopala's so and so, the certified copy of the registered instrument being received dated so and so was held not to be public record for a private document. This judgment has been followed in Rekha Ratnasri by Division Bench of Madhya Pradesh High Court in which it was held Rekha case. A deed of sale is a conveyance. A deed of conveyance or other document executed by any person is not an act nor record of any act or any sovereign authority. or of any official body or tribe or any public officer, legislative, judicial, and executive. Nor is it a public record kept in state of any private document. A sale deed, when presented for registration under the Registration Act, is not written or kept in our public office or state after registration, but is written to a person who presented such document for registration on the completion of process of registration. An original registered document is not therefore a public record kept as state or private document. Consequently, SOH. Then, Melody Lordship come to page 39. After extracting the Gopal Das judgment, just above para 23rd, just above the paragraph. Thus, the factum of registration, what is otherwise a private document, inter parties does not close the document with any higher legal status by virtue of its registration. Because one of the plea raised by my friends is that registration, the second defendant is made a part. Well, your lords may come to same page paragraph bottom. After considering the Olympus judgment, last sentence. Since a specific performance is a justiciable issue, triable civility, obviously the expression court occurring throughout the specific fact will have to be substituted by the arbitrator or the arbitral tribunal. This part of the reasoning in Alien's developer, in the following the same reasoning as an overruled Delhi High Court judgment, would fly in the face of Olympus and would therefore not be a good law. So Alien's judgment has been held as not be a good law, but this reasoning. Then, Melody Lordship may come to page number 42, para 27. 27 to 30, in fact. Para 27. Judged by these authorities, it is clear that the proceedings under section 31 is with reference to specific persons and not with reference to all who may be concerned with the properly underlying instrument or all the word. Clearly, the cancellation of the instrument under section 31 is as between the parties to the action and their previous and not against all the persons generally, as the instrument that is cancelled is to be delivered to the plaintiff. In the cancellation suit, a judgment delivered under section 31 does not bind all the persons claiming an interest in the property inconsistent with judgment, even though pronounced in their absence. A reading of section 32 and 30 of specific fact would also show that the reasoning of the High Court in Alien developers is flawed. Where, for example, in section 32, an instrument is cancelled in part, the instrument which is otherwise only an instrument inter parties cannot be said to be an instrument which remains inter parties. The cancelled portion being a cancellation to the word at large. That is indirect. Equally, under section 33, when company is required to pay the resolution return of benefit which has been received from other parties required to pay, is exactly the same as that which is required to be done under a contract with sanction cancelled. Then, well, para 29, they repeat that it's not an action in rate. Then your lordship come to the final paragraph on page number 44, para 32. The reasoning in the aforesaid judgments, that is for Alien's reasoning judgment, would expose the incongruous result of section 31 of specifically bad being held to be an in rem provision. When it comes to cancellation of deed by an executing a document, such person can approach the court on section 31. But when it comes to cancellation of deed by a non-executant, the non-executant must approach the court on section 34 of specifically bad. Cancellation of the very same deed, therefore, by a non-executant would be an action in person, since a suit has filed under section 34. However, cancellation of the same deed by the executant of the deed being under section 34 would somehow convert the suit to be in. All these anomalies only highlight the impossibility of holding the action. Therefore, in view of the change in law, well, I have entirely moved section 8 application, and therefore, accordingly, I have moved section 8 application. Well, instead of considering these aspects, well, I am not touching about other requirements of section 8. Now, your lordship may come to the impugned order. Impugned order in CMA 315. CMA 315. It starts at page number 8, Malad. Now, page number 12, para 8. The learned judge notices about the Alien developers law prevailing then. Page number 12, para 8. He notices about Alien developers. Then, my lord, your lordship may come to page 30, para 9. But the learned judge notices about the Vidya Tolia judgment. Sorry, my lord, your lordship, just go to page number 10, my lord. The learned judge attention was brought to the page 10, part of para 2. In between, when it shows Deccan paper mills of Regency Mahavir properties dated 9. So the learned judges in the attention was drawn to the judgment of taken papers also in that case. Then my lord, your lordship may come to page number 15, my lord, last para 14, I believe, page 15, para 14. What the learned says. It is pertinent to mention here that though the petitioner defendant raises plea with regard to that, it has always been ready and willing to get the issues resolved through arbitration. But as per the then prevailing law, it could not proceed with the arbitration proceedings. But the affidavit of the petitioner defendant number 1 is silent as to what prevailing law prevailed him to resolve the dispute through arbitration. This contrary to his own findings, my lord. He himself has noted on the Deccan papers as well as the Hellenes. But the learned judge says I have not what. Further, it is to point out here that DGP except with the parties pertaining 23.326 and till now the petition defendant has not made any attempt to resolve the dispute as per clause 25. And it is the respondent plaintiff who made attempt to resolve the dispute by issuing a legal notice and also by referring to dispute by assessment name of an arbitrator. The petitioner herein prevented steps taken by the respondent in resolving the dispute. Further, it is to observe here that even when the present petition is filed, it is a bounden duty of the petitioner defendant one to suggest the name of an arbitrator to resolve the dispute. Whether the name has to be deferred only in section 11 application, not in section 8 application. So again, this finding is wrong by the learned judge. Therefore, my submission is, I am not at fault. A dispute arose, no doubt about it. They refer to arbitration, but they withdrew it. When they filed a suit because the law has changed, I filed a section 8 application. Therefore, my submission is that there's nothing wrong on my part, and the learned judge completely erred in saying that I have not mentioned the law in the affidavit. Your lordship may take the synopsis filed by my friend Miller's judgment because Vidya which has been referred by, has also been filed by, therefore I did not file it, Miller. Your lordship may come to the Vidya judgment, partial payment, plea number 5. In the synopsis filed by my friend.
Is memo styled as memo?
Yes, it's filed as memo filed on behalf of petitioner of the first respondent. Now, in this manner, your lordship may come to page number 5.
Vidya.
Now, this Vidya judgment of 3 judgment has been referred to larger bench, but till now it still is hold. So now, in the same judgment which my friend is relying upon, your lordship may come to para 48. Para 48 is not page number 64. So the identical issue was raised. Para 48 and 49 discuss about what is action in rem and what is action in persona mallet, and they also rely upon the refer to Puzzle judgment. Para 48 and 49. Then after noticing I am not troubling your lord, then your lordship may come to para number 74. But 75, not 74, abital judgment. Number 75, they take note of the Deccan paper mills judgment, para 75. In a Deccan paper mills pursuant, so legal proceedings for cancellation of documents 31 was supposedly filed. It was held to be actions in personam and not action in rem. Significant judgment referred to the definition of action in rem by so and so. So, Deccan papers have noted, not been overruled. Then your lordship may come to page 76, para 76. Page 76, para 76. What is the law later? In view of the above discussions, we would like to perform a fourfold test for determining when the subject matter of dispute is in arbitration agreement is not arbitrable. When cause of action and subject matter of dispute relates to action in rem that do not pertain to subordinate rights in the personam that arise from the right in them. Well, the specific performance right in personam in the sense it's an intersect dispute. Number 2, when cause of action subject matter of disputes affect third party rights, have ergo omnes effect, required centralized adjudication and mutual adjudication would not be appropriate and enforceable. 3, when the cause of action subject matter of dispute relates to inalienable sovereign and public interest functions of the state and hence mutual adjudication would be enforceable. When the subject matter of dispute is expressly or by necessary implication non-arbitral as per the mandatory statutes. These steps are not watertight compartments. They dovetail and overlap, albeit when applied holistically and practically will help and assist in determining and ascertaining the great degree of certainty when, as per law in India, a dispute or settlement is not arbitrable. Only when the answer is affirmative, that the subject matter of dispute would be non-arbitrable. However, the opposite principles have to apply to care and caution. Then Olympics have been done, my lord. Therefore, my lord, my submission is that it's purely an arbitrable nature. One of the ground raised by my friend is saying that defendant number 2 has been made a party. Defendant number 2 is a registrar who has been made a party to delete the entries in the register. So therefore, it's not arbitrable nature. That has been answered in para 77 of this judgment only, page 76. It's only for the purpose of registering things, my lord. Where they talk about registration. Now, my lord, last to conclude my arguments for whatever my bench is. My lord, let me take the plaint, my lord, for the prayer. It's I didn't accept the relief sort of cancellation. There's nothing else except to get it registered. Plaint is filed, my lord, at page number. Page number 27. The prayers are at page number 32, man. Prayers. Page number 32 are the prayers, man. But all the reliefs, if you also would notice, all the reliefs sought are relatable to the development agreement, arise under development agreement, page 32. Now, only prayer which my friend is stating that it's not arbitrable is prayer E, my lord, to carry out correction register by removing the entry of the development agreement, document number 66 dated 23/2/26, because defendant number 2 has been a party. My lord, this is also in respect of development agreement only, because it's a more like a ministerial work as my lord, after as a consequential to the relief granted. Therefore, my lord, this will not compare or come in way. So this could be an arbitrable in nature. Therefore, my submission is the order of the trial court. Commercial court erroneous and its effects.
Please, Your Lordship. Well, a little more addition to the facts of the case as submitted by Lord Counsel. Well, 2006 is the development agreement. I have handed over my lands in favor of the appellant before Lordship for development purpose. Well, 17 years have passed, no development has taken place. No development can take place in future also, because my lord, these lands are covered by GOMS 111, which prohibits my lord any construction to be brought up within 10 kilometers from the water bodies. These lands are situated within that region, so he can never develop these lands. We want to put them for agricultural use. We cancelled this development agreement in 2012. He disagreed for that. Then 2016, my lord, we went before arbitration. We appointed a learned senior counsel of this court as our arbitrator. They appointed a retired judge of this honorable court as their arbitrator. Both of them have mutually appointed another retired judge as a presiding arbitrator. Arbitration proceedings have commenced. My lord, if your lordship kindly takes up the counter file by me, apart from the memo I filed, I have enclosed my lord documents relating to the proceedings that have taken place before the arbitral tribunal. Kindly see page 6 of it, counter file by me. Yes. In that, kindly take page 6, my lord. The first proceeding before the arbitral tribunal, dated 23rd November 2016. My lord, there both the parties have participated, appear before the arbitrators. And my lord, your lordship may kindly see the formal things have been recorded by the arbitrators in the first meeting. And they have fixed in the page 7, my lord, the schedule of the arbitration proceedings, the dates by which the pleadings have to be done, and the place by which, my lord, the draft issues will be framed, etc. All those things. Then, my lord, at page 9, the appellant before lordship has filed a petition under section 16 of the Arbitration Act, saying that this dispute is not arbitrable. Page 9. Where your lordship will see at page 11. Hence, prayed that the
The arbitral tribunal may be pleased to rule in its own jurisdiction in pursuance of provisions under section 16(1) of the Arbitration Act with respect to arbitration claim made by the respondent and be pleased to terminate the arbitration proceeding as not maintainable and pass circular order so and so. Then, my lord, in the subsequent meeting at page 13, subsequent meeting of the arbitral tribunal at page 13, my lord, in view of this objection raised by them, my lord, my client has decided to withdraw it. My lord, these proceedings I read out to lordship. The parties invoked the arbitration under a development agreement dated 23/6/2006. On claimant filing a claim petition, respondent filed IA under section 16(1) of the Arbitration and Conciliation Act on 2/1/17 to rule on the jurisdictional tribunal for granting the relief claimed in the light of judgment in 2015 6 ALD 584. Today, claimant have filed a memo seeking leave to withdraw the arbitration proceedings with liberty to work out remedies before the appropriate forum. The claimant is permitted to withdraw the claim. Liberty is granted to pursue such other remedies as are available under the law. Arbitration proceedings are accordingly terminated. Their parties, my lord, even for the termination of the arbitration proceedings, wherein, my lord, I have informed the tribunal that I will be working out my other remedies. My lord, I mean, my lord, I mean, they also agreed for that. For proceedings have been terminated. Then, my lord, I filed the civil suits for recovery of, my lord, I mean, for cancellation of development agreement. In the context of, in the background of these facts, my lord, I mean, the law laid down by the Honorable Supreme Court in the case of Deccan Papers, etc., is something different. But what transpired between the parties is something different. My submission to the Honorable Court is, my lord, arbitration is a mutually agreed process of dispute resolution through a private forum. Parties have agreed to it, my lord, parties are bound by it. Parties have resorted to it. Tribunal was constituted. Before the tribunal, one party raised objection, other party said that I will go before the other forum. Tribunal has accordingly terminated the proceedings, my lord, which falls under section 32 of the Act. Tribunal can, my lord, terminate the proceedings. Terminated, my lord, I mean, the only remedy available to me is filing a civil suit, my lord, I filed the civil suit. Now, my lord, taking the general law laid down by the Honorable Supreme Court in the 2020, my lord, the appellant before lordship takes an objection that because of this change in the law, you must again come back to arbitration proceedings. My lord, in view of what has transpired between the parties, my lord, my humble submission is not permissible to the appellant, my lord, to say that invoke section 8 of the Arbitration Act and also say that arbitration is the only mode, my lord, I mean, between the parties to resolve the disputes. In that context, my lord, that is my first submission. In that context, my lord, in the memo which your lordship has seen where I filed judgments, I placed a judgment before the Honorable Court at page 195. My submission is, my lord, that the appellant is stopped from, my lord, pleading that I have to go before the arbitrator once again. My lord, kindly see at page 201, paragraph 17. On the whole, an estoppel seems to be when, in consequence of some previous act or statements to which he is either party or privy, a person is precluded from showing existence of a particular state of facts. Estoppel is based on the maxim, allegance contrary honest audience. A party is not to be heard to allege the contrary, and that a species of presumption juris et jury, where the fact presumed is taken to be true, not as against all the world, but against a particular party, and that only by reason of some act done, it is in truth a kind of argumental and hominum. Then, my lord, another relevant paragraph at page 203, paragraph 26. Estoppel then may itself be foundation of a right as against the person estopped, and indeed, if it was not so, it is difficult to see what protection the principle of estoppel can afford to the person by whom it may be invoked, or what disability it can create in the person against whom it operates in cases of affecting rights. Where rights are involved, estoppel may with equal justification be described both as a rule of evidence and as a rule of creating or defeating rights. It would be useful to refer in this connection, so and so, judgment. And the last paragraph of this judgment, my lord, I submit to lordship is page 206, paragraph 37. if a man either by words or by conduct has intimated that he consents to an act which has been done and that he will not offer any opposition to it, although it could not have been lawfully done without his consent, and he thereby induces others to do what which they otherwise might not have might have abstained from, he cannot question legality of the act he had sanctioned to the prejudice of those who have so given faith in his words or to the fair inference to be drawn from his conduct. My lord, my humble submission is, my lord, this estoppel as laid down by the lordships applies to the facts of the present case, because my lord, when before the arbitral tribunal, I expressed my intention to go before the other remedies open to me, and my lord, I mean, impliedly they consented for it. That has been recorded by the tribunal, and my lord, proceedings have been terminated. Accordingly, I went before the civil court. Now, my lord, I mean, they can't turn around and say that you must again go back to arbitration because of the general law that has been laid on the Supreme Court. Well, this is what happened between the parties. I mean, the general law laid by the Supreme Court will not have any binding nature on the parties before the Honorable Court. That is my humble submission. And secondly, other submission is, my lord, in this case, it is not only, my lord, the cancellation of the development agreement I sought for before the civil court. I also, my lord, sought for a direction to enter in the books of registrar cancellation of this particular entry also. Council has read out that portion to lordship already in the main appeal papers, my lord, which they filed. The prayer is at page 32. One of the prayers is, my lord, subclause E, to carry out correction in the register by removing the entry of development agreement document number so and so so and so. This is a sovereign function of the sub-registrar. I made sub-registrar as the second defendant in this suit. My lord, this function cannot be, such a direction cannot be given by the arbitral tribunal to a sub-registrar because it's a sovereign function of the registrar. My lord, I mean, such a direction can be given only by the civil court, my lord, I mean, to the sub-registrar also. So, my lord, this falls within the, this judgment, my lord, which I place Vijaya Drolia at paragraph 76. Paragraph 76, my lord, the lordships have summarized what the law they are laying down. Paragraph 76, my lord, subclause 3, when cause of action and subject matter.
1 minute.
Yes.
Oh, which, Vidya Trodia, which page?
My lord, page 76, page 76, paragraph 76. In view of the above discussion, we would like to propose a fourfold test for determining when the subject matter of a dispute in an arbitral agreement is not arbitrable. When cause of action and subject matter of dispute relates to actions in rem that do not pertain to subordinate rights in personam that arise from rights in rem. When cause of action and subject matter of dispute affects third party rights, have ergo omnes effect, require centralized adjudication and mutual adjudication. Then next one, when cause of action and subject matter of the dispute relates to inalienable sovereign and public interest functions of the state and held, and hence mutual adjudication would be unenforceable. One of the reliefs I sought for before the civil court is to direct the sub-registrar to they delete the entry relating to this development agreement from the books of the registrar. It is a inalienable function of the state. Such a direction can be given only by the civil court, but not by the arbitral tribunal. So, my lord, this falls within the law laid down by the Honorable Supreme Court, and hence, my lord, this suit is maintainable.
So what happens to a case where some of the reliefs are arbitrable and one part of the relief is non-arbitrable?
Yes. Well, for that also, I filed one more judgment. After this Vijaya Drolia case, Lordship will see at page 167, 167. Relevant paras would be para 17.2.
Oh, you are referring to a judgment at page 167.
Yes, 167.
Gujarat.
Yeah, Gujarat Composite Limited Infrastructure Company, so and so. This is a Supreme Court judgment.
Page
192. Paragraph 17.2. There being no doubt about the non-existence of arbitration agreement in relation to entire subject matter of the suit, And when the substantive relief claimed in the suit falls outside the arbitration clause in the original license agreement, the view taken by High Court does not appear to be suffering from any infirmity or against any principle laid down by this court. Then also, my lord, page 194 also, paragraph 20. For what has been discussed here in above on the facts and in the circumstances of the present case and in the nature of transactions as also nature of relief claimed in the suit, view taken by commercial court and the High Court in declining the prayer of the appellant for reference to arbitration cannot be faulted. That's also the case where one of the reliefs and one of the parties to the suit proceedings are not covered by the arbitration agreement. So, my lord, keeping that in view, the lordship says that the suit is maintainable. So, my lord, in the present case also, keeping in view, my lord, the relief claimed and also the parties who are made the parties to the suit, my lord, the arbitration proceedings are not, the dispute is not arbitrable, and so it has to proceed before the civil court, commercial court only. That's one submission.
The first one is the legal aspect, which is law. But my friend has been saying that he has been made a party, the register, the sovereign function is being carried out. To appreciate it, the lordship may come to page number 27, the plain, where the plain starts. Lordship got it? It's a plain one. Now, your lordship notice, defend number 2 is the joint sub-register Rangareddy, and below that, your lordship notice plaintiff's own endorsement. No relief is claimed against defend number 2 and has been made a formal party for execution of the award. So, it's only a ministerial job. Which is note that is for. Okay. My lord, this was precisely the plea raised or plea withheld, upheld in the Ellen's judgment of this division bench, which has been overruled by Deccan paper. That is, that entire paragraph has been extracted, just now read, and then it has been overruled. Then, your lordship may take my description of the citations. Your lordship may come to the last judgment. Krishna was the Banaras in the university. That's right. Now, at page number 63, 2028 Supreme Court. And in this, your lordship may come to page number 73. It's settled law, but just read it. Therefore, I did not read it. Para 32, page 73, para 32. Further, in Tata Chemical also, so it has been laid down that there can be no estoppel against the law. The law requires it to be that way. The principle is there can't be estoppel. But if Karnataka High Court in the way that Supreme Court, it was a case where the party by conduct permitted for execution of the sale deeds. So in that context was said he was estoppel, not on the law. Here the law has changed. That's one thing. Second, what my friend has read, the same judgment of Gujarat Composite, that's also not applicable. The lordship may come to the page number 195. Not 197. Gujarat Composite. The issue which arose because your lordship asked a query, some of them is active, some is not. But that law has been laid down by Sukanya Holdings and has been followed up. But this was not the case on this. Your lordship may come to page 167. And the issue which was involved is, your lordship would get it at, apart from the page number 192, my lord. It starts from 191, in fact. There were 6 agreements between the parties, page number 191, my lord. Different parties. Your lordship should notice contracting parties were different, and whether the arbitration clause existed or not was also mentioned therein. So some of the clauses had an arbitration clause, some of the clauses did not have an arbitration clause. Not the subject matter, page number 191. So they gave a tabular column. Then your lordship may come to page 192, para 17. My friend read para 17.2, but your lordship may read para 17. Except the principal agreement dated 7/4/2005, none of the other agreements contained any arbitration clause, even if they related to same property and also involved the appellant and respondent one. The latter transaction involved other parties too, like the tripartite agreement dated 6/7/2006, whereby the respondent to bank sanctioned loan to the respondent one and the supplemental to said tripartite agreement for dealing with the deposit of title deeds. Similarly, other deeds of conveyance dates involve the appellant and other defendants. The aforesaid position of the dealings of the parties when examined with reference to reliefs claim the suit and the cause of action pertaining to said reliefs, as extensive notice by the High Court and extent been above. We are a clear view that sufficient measures apparent with reference to amendment of Section 8 and later decisions of the court in interpretation of the apparent do not inure to the benefit of the apparent. This is for simple reason that no such condition can be provided in the original agreement. So that there was parties were different. There was no arbitration clause. In the light of that, Section 8 was dismissed. So there is completely different judgments not applicable. Therefore, my submission is that.
All right. Reserved. Mark the present submissions. Just now. Yes. Oh, this is separate set, right? My set. You read, keep it. Just send it. Huh? No, there is still nothing run.
Please, Lord.
Oh, yes.
But the first of all, brief synopsis. Brief synopsis and submit. Sir, just now.
Just now. Let's see.
Yes, the PI number 68, man, on top.
68, right?
Yes. Not in this matter. The Tune Geo, which is under challenge.
Where is that order?
Geo, which is under challenge.
Just type. No, not synopsis. Other order which was said. Just where she has typed. Not ready. Give it to him. Give a copy to us.
Hello, the impugned Geo, which is under challenge, is at page 59 of the writ petition memo. That government order, what is being proposed, my lord, is regularization of
sale transactions in urban properties which took place on the basis of unregistered notarized documents. This government order, Manoj, on the basis of the note at page 60, paragraph 2, on the basis of these notarized documents, property tax receipt, electricity receipt, water bill, any other proof to establish possession, they now seek to regularize these transactions, which are squarely contrary to the provisions of the Registration Act, Stamp Act, and Transfer of Property Act. Section 54 of Transfer of Property Act very categorically states that a sale of an immovable property has to be only by way of a registered document. Registration, my lord, in 17 of Registration Act is mandatory where any immovable property more than 100 rupees in value is being transferred. Then your lordships will see at page 60 what the exemptions which are being granted to these persons who have not executed transfer documents or sale deeds on and registered them. There is an exemption being given to persons who have in fact defrauded the state, my lord, by not paying stamp duty, not paying registration fees for any property which is in an area of 125 square yards or below. Stamp duty is being exempt in full and a mere penalty of ₹5 is being levied on them. This, my lord, is in violation of Article 14 also, because there is no differential between those who have executed these notarized, so-called notarized documents and those who wish to enter into sale transactions today on the basis of the same 125 square yard criteria. Therefore, no reasonable nexus or intelligible differential, my lord, between, and in the same page, my lord, para 10.
1 minute. What is this document, Mr.?
Yes, ma'am. Page 59, my lord.
What is it?
This is a government order where the state proposes to regularize sale transactions which were entered into between parties on the basis of unregistered documents only with notary method. Only on the basis
The
of,
regularized document means what? How can it regularize?
yes, madam. Our challenge is on that basis that when the statutes require that it has to be a sale can only be by way of a registered document, the state now proposing to regularize such illegal transactions would be in violation of statutory provisions and Article 254 of the Constitution of the Manor and in violation of Article 14, where
What does this expression mean, regularization of notarized documents?
they have filed a counter, my lord, saying that we are not going to register. We are only seeking to take stamp duty, and they admit that they're not registering, but on the same hand, they say we are regularizing.
What is that?
Your lordship will see the effect of such regularization at page 60 of the writ petition. page 60, paragraph 10, the Roman numeral 10. If this sale or if this transfer document on the unregistered document is regularized, the effect would be at para 10 at the bottom of the page, my lord, the registering authorities in the state shall accept all these documents as valid linked documents for further transactions. My lord, that is illegal. Honorable Supreme Court in Suraj Lab's case has very clearly said a sale has to be by way of a registered sale deed only. On one hand, in the counter, they say we are not taking up these documents for registration. But your lordship will see the effect of this is it is deemed to be a registration and it shall be valid for all further transactions.
So you are for the time being concerned with clause 10.
Clause 10, my lord, and your lordship will see paragraph 2 right on top of the page. This has an effect of doing away with a person having to file a case.
No, paragraph 2 is shall submit an application
Yes,
with me.
on the basis of only on the basis of these documents, the transactions or the possession will be deemed to be valid. Now, this is for a court of law, my lord, to decide on the basis of either a suit for specific performance or a declaration suit on who is the title holder, who is in possession, who is the owner of this property. A collector cannot.
See, Mr. This, it's not possible for us to decide everything at motion hearing stage. What is your prayer for interim relief?
Prayer for, I've asked for suspension of this year because they've given a 3 months time limit. The 3 months expires on 31st October 2023.
1 minute. You give a copy to Mr. Copy. Give a copy.
And in fact, on
1 minute, just give us. Give a copy. This is the copy, Mr. Prasad, for you in that. Please send it immediately. Yes.
In fact, my lord, in another matter, PIL 63 of 16, where building illegal constructions were sought to be regularized by the state, this honorable court had said there's a matter which is pending before the honorable Supreme Court, and therefore there is no urgency, and granted an interim order not to regularize it. I'll just ask for that. The status of the honorable Supreme Court matters also passed along. In this case, my lord, where at present before the honorable Supreme Court, the next date is 27 September 2023, where regularization of illegal constructions across the country is being heard by the honorable Supreme Court, and when a similar PIL was filed with respect to regularization of illegal buildings, this honorable court has stayed that geo and said since the matter is pending seized off by the honorable Supreme Court, the regularization itself should not be allowed for illegal construction.
Now, what do you say, Mr. Prasad?
My friend may not be apprehensive of the fact that the state is going ahead with the registration and is violating Transfer of Property Act and Registration Act. Kindly see what the state is now doing. The notarized documents which are in place already, only stamp duty under Section 9 is being levied, nothing else. but the statement which is being made, the affidavit government which are made, but are in the context of Transfer of Property Act and the Registration Act. Both are not the subject matter of the GOs. This is a policy decision taken, my lord, in respect of people, my lord, who own less than 125 square yards and also above that. There are two separate GOs, my lord, which are operating in field for the lands for the extent of 125 square yards and above. GO 58 and 59, you know, they are subject matter of other issues. Kindly see, my lord, I filed a counter, detailed counter, setting out the details, my lord, saying that under section 9 and 38, 40, 42, the authorities can collect stamp duty. The extent of collecting stamp duty, my lord, what am I doing, my lord? I'm
No,
bringing
see,
the
Mr. Two things we need to understand. Like, I mean, you are regularizing the note. What does regularization mean? And then the clause 10, you say registering authorities shall accept as a valid link. So you are saying, one hand you are saying, see, we trying to understand with an example. Like one hand you say, no, we are not registering any document and we are not treating it as any valid sort of a transfer in contravention of the Transfer of Property Act or Registration Act. Then at this clause 10, you say that they shall accept as valid documents. Supposing if I have whatever you said 25 square feet. 125 square yards.
Poverty land.
125 square yards. I have a plot, and I have sold it to him by this thing notarized document, right? And you recover stamp duty. Then supposing tomorrow if he wants to sell it, you direct the registering authorities to accept it as valid document. So is it not this clause 10 at least does not infringe the provisions of this thing, Transfer of Property Act and Registration Act?
Give an example. What is happening now? Notarized documents are many in number. The state, lot of executed documents are executed just lying there. Now,
Let them do what they want to do, Mr. Any this thing. Why do you get into it like this? The government should not act in contravention of the like. This is what this direction contained in clause 10. What is the effect?
But but after you collect the stamp duty, in case you are by collecting stamp duty, you are getting into the regular stream. But subsequent to which, in case it is attracting, if it is affecting transfer of property, then 17 will apply. But 17, for the purpose of 17, the stamp duty collected can be treated as a link document, and for the purpose of civil suits, the documents can be accepted. Civil suit, specific performance suit, after collecting of stamp duty, they can be accepted as a piece of evidence.
Registering authorities.
The registering authority can treat this as a link document for the purpose because duty is collected. But to bring it to the
like it will be a valid title, right? So subsequently, supposing if he wants to sell it, on that he will produce it along with the sale deed to or whatever, and it will be a valid document, right?
These are the documents which were entered into between two parties. 22A of the Registration Act takes care of the properties which belong to the state. They cannot state lands which are fallen by virtue of
Registration Act.
Well, I'll just 22A, if your lordship sees, the category of it. of the Registration Act. But the properties which are belonging to state, central government, agricultural land ceiling, urban land ceiling, and also Endowment Act.
No,
They are prohibited.
22A, please read.
But the following classes of documents shall be prohibited from registration, namely documents relating to transfer of movable property, relation of or transfer is prohibited under any statute to the state or central government. Documents relating to transfer of property by way of a sale, agreement of sale, the gift, exchange or lease in respect of immovable property owned by state or central government. executed by persons other than those statutorily empowered to do so. Documents relating to transfer of property by way of sale, agreement of sale, gift, exchange or lease exceeding 10 years in respect of immovable property owned by religious and charitable institutions falling under purview of.
No, that's correct.
But
So-
these accepting properties which are under E, we need to notify where the properties are subject matter of crime. Other properties which are subjected to agricultural land ceiling, urban land ceiling and being owned by state and central government by virtue of endowments of other act. But those properties are prohibited from registration. Where those properties are already registered, already sold, but GMS number 59 is issued by the state, which takes care of those properties to be regularized under 59, where the unauthorized sale is there and where the government is, the exchequer is put to loss by virtue of non-payment of stamp duty and also registration. 58 and 59 takes 58 is a GO that is issued in respect of a class of person who are falling under below poverty line by owning less than 125 square yards. They are totally exempt.
No, but how do you define? I mean, this is a prohibition of registration of documents. You are taking a plea. We are not registering any document, right? Which is not required to, which can't be registered under the Registration Act. You are not registering
These are
it.
the four classes of property.
Then, right? So, then if you are not registering the document, two things we would like to understand. What is this concept of regularization of notarized document and clause 10?
Well, regularization of probably the term may not, in the GO may be incorrect. I'm sorry to say so. Regularization respect by collecting stamp duty under section 9, which the state is empowered to, or in respect of notary, by virtue of which the stamp duty is also not paid, the state exchequer is at loss actually. State exchequer is put to loss by virtue of a series of transactions without payment of stamp duty. Section 9 of the Stamp Act, if you're not.
That was one of our.
Power to reduce remit or compound duty.
125 Act, we are now actually exempting it. Less than
Section 9 of the Indian Stamp Act.
Yes. Where you have reduced the stamp duty and penalty to 5 rupees. That's why we are saving down the 9. May I read it, Manoj? Government to satisfy the necessary to do so in public interest may by rule or order published in official gazette reduce or remit whether prospectively or
This you are referring to Indian Stamp Act.
Yes, Indian Stamp Act.
Section 9.
9.
The government, if satisfied.
Yes.
That it is necessary to.
To do so in public interest may by rule or order published in the official gazette reduce or remit whether prospectively, retrospectively in the whole or any part of territory and the administration, the duties which with any instrument or any particular class of instrument or any instrument belonging to such class or any instrument when executed by or in favor of any particular class of persons or by or in favor of any member of such class are chargeable. Provide for the composition or consolidation of duties in case of issues by any incorporated company or is not applicable. Kindly now.
So, what is your submission? It's under section 9.
Yes, collection of stamp duty in respect of notarized document.
No, it goes beyond collection, right? I mean, you could have said that we will not recover any this thing, reduce or remit. We will not recover those who have recovered are entitled to refund, or reduce that instead of this rate we will at 1% we will charge. But you go beyond that section 9 and say that this regularization of document, what does this mean exactly?
Here we are charging 5 rupees as penalty over above stamp duty. Respect of persons who have not availed.
No, that's correct, Mr. That is section 9 is your power.
Yes.
But what is your submission? Order is not within this.
Section 9, we are now what?
This is section 9, subsection 2A. It is applicable to this class of instruments.
Right. I'm sorry. In this section, the government means.
Please 2B. 2A, line 2A.
In relation to stamp duty in respect of bills of exchange, checks, promissory notes, bills of lading, letters of credit, policies of insurance, transfer of shares, debentures, proxies and receipts, in relation to any other stamp duty chargeable under this act, falling with entry 96 in list 1 schedule, except the subject matter referred to in clause B, subsection of central law.
So it implies that it doesn't apply to any agreements made under a notary. If you're referring to 9,
Yes.
that class of document is not referred in this, so it's not applicable.
No. The document to be will apply.
B.
This is essential laws. This, what the government is, if it is central government.
Yes.
Save as aforesaid in respect of clause.
A only would.
State law. Composition comes, this will apply. This will apply. This B will apply. 9(1)B will apply, Mr.
9(1)B.
In case of subsection 1B.
Yes.
9(1)B. That see, it can be this thing. State government is competent to provide reduction or remission.
Yes.
Of stamp duty or compounding duties in respect of policies of insurance in case of issues by incorporated company, other body corporate, or of transfer where there is a single transferee of debentures, bond shares, policy of proxies, receipts, and other marketable securities. It's not outside section 9.
Yes. But what I was submitting.
We will, yes.
But I'll just go to the GO minute. Yes.
You don't do anything, Mr. in furtherance of this. In the meanwhile, we are passing an interim order.
Insofar registration is concerned, madam, collection of stamp duty or registering the document.
No, this we have considered your submission that it is section 9, right? And
Clause 10, your lordship.
clause 10.
Clause 10, your lordship, by pointing out that this, if I may read it for my benefit. Registering authorities in the state shall accept all these documents valid documents for other transactions. But this was pointed out by my friend. My lordship have also put a question to. So by stating this as linked document for the purpose of registration, the lordship may consider granting an order. So by collecting of stamp duty, what is happening now? But it's a benefit to the state exchequer, augmenting revenue.
No, but under you have to do it in consonance with law.
Yes.
So if it's not under section 9 of the Stamp Duty Act, how do you this you have seen just now? We'll record your submission. Heard on the question of interim relief. Learned counsel for the petitioner submits that impugned GO date admitted for hearing. The beginning you write. This is which was, this is item 22. All right. You have got the copy, Mr. Prasad. Please see that.
Not saying anything, but Lordship are required that I assure the court the official direction issued by the court will be followed meticulously. But let the authorities follow it. I'll assure that the order is communicated to him.
So he would give that.
I see that the order is communicated right away to the authority.
You give that order we have signed also. Get it, madam. But if you feel diffident, then how this will be implemented, right?
But I will.
We appreciate your difficulty, but I mean, this has been done so as to emphasize upon the authorities that they shouldn't go ahead.
I'll communicate.
Learned assures this court that the direction is. You type it just now.
I'm deeply obliged.
Yes. Let her type. We will sign it, then only we will get it. You give him another copy, just in our presence. Yes. Wait for a minute, Mr.
I'll be here.
Yeah. Yes. Hmm. 23, 24.
I have
Lordships may kindly pass over this one.
on account of some unforeseen contingency, I have not been able to come physically. May request that the other side may complete the arguments, and I will come and address my Lords Miller on Monday, on Tuesday, 3rd of October, Miller.
3rd of October.
My lord, kindly take it up at 2:30, my lord. Mr. Mohan Reddy will come.
Yes. No, that what is saying, yes. That you can complete the submission.
Yes.
He will, for rejoinder submission is saying 3rd October.
Yes. I'm deeply obliged.
He said that obviously there is no time.
Yes.
We are waiting for her to take that order, which is can be given.
Yes.
That's
right. Yes.
All right.
Great.
See, for hearing. Again. The order of for hearing 21 cases.
We signed case and mentioned it.
He is not, Mr. Reddy is not getting it. See what I told him. That when we got this, the oldest matter should come first. See, these 1, 2, 3, and 20, this thing, we are getting special attention. Direction is to all the respondents. Our direction is to all the respondents. No, basically, but mainly the police, right? Police authorities can only prevent, nobody else. No, and you have seen, Mr. You have made this thing, a sort of a pandal in front of that lake where police officers are sitting to help the immersion, presumably. We don't know what is going on. No, the extent possible means you have to comply, no other option. This you have said that baby ponds and all that, where are people? You see Times of India, this thing, newspaper, we wished that it's wrong. You read it, you must have read it.
Your Lordship's kind leave you. Item 98, your Lordship, the party is out of country.
Lordship,
98?
98.
Ah,
3 weeks accommodation will settle.
which case? 98?
90.
What is the number? We don't know. It will not reach Mr. Rao.
But your lordship, sir, the party is out of station. 3 weeks, your lordship.
You are very much in station, Mister. You don't need party to argue.
The affidavit has to be filed with some crucial documents, your lordship. That's all.
Which case 98? Which of the year? Which year? 2008 matter, Mr. Rao.
No, your lordship, may kindly, I will not take next adjournment, but this out of session, your lordship, out of country.
So what? 98 Mr. C. Hanumant Rao, Learned Counsel, prays for adjournment. It is made clear that by way of indulgence, hearing is deferred by 3 weeks. It is made clear.
Much.
Page 32 is covered.
22.
Page
Huh?
22.
Page 22. Disposed of. Certified copy today.
Published.
Item number 2, similar order, not, page number 30.
32.
30.
32. 30. Page 30. Disposed of.
Item number 2, page number 31.
31. Four.
Page number 28. 28.
28. Item number 428. Certified copy.
Item number 5, 32 becomes.
32.
Item number 6,
Got it, Mr.
item number 7, again.
Page number 27.
27. Yes.
Item number 13, Rams.
Page number 20, Manu.
21. Yes.
Item number 14, P. Chandana.
Your Lordship, at page 54, Your Lordship.
What is the order?
Top.
54. Page. She may not know. Page 54. All right. Yes. 54.
Much obliged.
She may not know. Page 54. Yes.
Right, please. May I pass on for your lordship's kind consideration a list of dates, Madam, so that easier for you.
Where is my notes like this? Notes. My notes, Mister. I had taken this one. Notes. Not there. Give. Yes.
Right, please. Let's let me begin this. The whole period, the writ petition, both the writ petition, when they're based on a false narrative. The true facts are never placed before the sun. The attempt method is to club demerger.
You are for AP Gen.
Respondent number 5, it's AP Gen 2. Whose account is adopted by the state government, second respondent. Second respondent is the state government. They have filed a memo minute adopting the account of it. But both the writ petitions received minutes, I take the lots, so just minute, 1 minute of Lordship's time. On the basis that there are certain demerger issues relating to power utilities. And unless those issues are decided, the amount payable for the power supplied post bifurcation from the effective date, they will not be. They want to link up demerger issues with post bifurcation used for the electricity that was supplied by the state of Andhra Pradesh, by the GENCOs. Civil Lordships will bear in mind the post bifurcation, whatever power was supplied at the expense of the AP GENCO. The coal was purchased from its own funds. Does not do with the demerger issue.
This is post bifurcation period.
Yes. With effect from 2/6/2014. But once these two issues are dealing,
Two 2014 to
the supply was up to 10th June 2017. On which day on the both the GENCOs stopped supplying the power to the other side. By virtue of I just take your lordships to the list of dates. May I just read this from the list of dates? That relevant point, I'll point out the document also. PPAs were entered into between AP GENCO and AP DISCOMs. That is EPDCL, that's Eastern Power Distribution Company, SPDCL, Southern Power Distribution Company, CPDCL, Central Power Distribution Company, which is now designated as TSHCL. And AP NBDCL, that's Northern Power Distribution Company, which is now known as TS Northern Power Distribution Company. The PPAs were filed in the APERC for approval as required under Section 86(1)(b) of the Electricity Act 2003. However, the PPAs were not approved as on the date of bifurcation. Your Lordship may note this fact. A lot of emphasis was being laid by the Council for the Senior Council for the petitioner about the pendency of the PPAs and reneging of the AP GENCO from the PPAs. As per GOMS 20 dated 8/5/2014, this was issued prior to bifurcation notified date by virtue of a recommendation made by a committee constituted by the state of Andhra Pradesh. The installed capacity of all the generators were apportioned between AP and TS, AP share being 46.11% and TS share being 53.89%. AP GENCO has obligation to supply power to APDCL, APSPDCL, and APCPDCL and APMPDCL even after the bifurcation of the state. And that's also by virtue of Section 92 read with Schedule 1, Item C. I am bound by the PPAs or existing PPAs will continue. And 12.7 says, whichever state has the deficient power, it has the first right of rejection. So I'll have to first offer them the power if I have an extra power, and they have the right to reject. Then I can sell it in the open market. There is absolutely no dispute about this. The existing PPAs will continue. The question that would arise for a large consideration is whether the PPAs were in existence at all. PPAs were pending before the erstwhile AP State and City Regulatory Commission, SCRC, APSCRC. They were not approved as of the date of bifurcation. Therefore, my lord, the contention of AP Genco is that there was no approval to PPS. So there are no existing PPS which will be valid for 10 years from the date of bifurcation, as my lord contemplated under clause C of Schedule 12. My lord, then I have given the figures, my lord, as on bifurcation date, that's on 2/6/2014. The installed capacities of both the states are as follows. AP Genco Thermal 2810 megawatts, AP Genco Hydel 1656 megawatts, TS Genco Thermal 2282.5 megawatts, TS Genco Hydel 23160 megawatts. Merit the Telangana had higher power generation insofar as hydel power is concerned. Insofar as thermal power is concerned, AP had higher capacity. But if the generating capacities are to be distributed, PS has to supply excess power to the Andhra Pradesh. Pausing here for a minutes. Neither Telangana supplied hydel power to Andhra Pradesh, nor Andhra Pradesh supplied hydel power to Telangana. There is no dispute about it. Neither Telangana raised a dispute, nor Andhra raised a dispute, though Andhra was losing out cumulatively. Because total capacity is taken into consideration, the Andhra would have got 175.76 megawatts hydel power in excess, which they did not say. I'm not making an issue out of. I'm just trying to point out, because it was sought to be contended by the learned senior counsel for the petition. The project as if Andhra Pradesh is the party which has violated all the provisions of the statute, which has not complied with the requirements of law. Then you watch me go to the next. 17/6/2014, Government of PP has taken a stand to rescind the PPS since there is no regulatory approval for PPS and requested to schedule the power of those projects located in AP state to AP SPDCL, AP so on. Your Lordships will get this decision at page 137. I will not trouble your Lordships reading that decision because it had no effect at all. On 18/6/2014, your Lordship, this is very important. On 17, it was informed, Government of AP informed Gencos to discontinue supply of power to TS Gencos. Before this continuation could take place, the POSOCO is a company and a statutory company constituted by the Union of India under section 29 of the Electricity Act. It gave a direction to the APSLDC, that's State Load Dispatch Center, SLDC State Load Dispatch Center, to continue with the existing scheduling procedure in force since 2/6/2014. May I just take your lots to this communication?
Can you formulate your submission so that we appreciate? So far,
But I thought I'll make the facts a little clear because the facts are not come out really as they should have. But once I complete reading the dates, I'll just I'll frame them. There will be just one or two questions that I need to answer. That or I would be framing in the light of what submissions were made. 18/6/2014, POSOCO issued a letter. Your Lordship should get that along with the counter is 82. May I invite your Lordship's attention to that paper.
Mr. Counter in WP 37555.
Right, it's filed along with IA 2 alert for vacating the.
Reference counter WP 37555. A counter, what counter or vacate petition? Because here there is a counter reference to counter in the note which is given
Well,
to
there's the counter affidavit in the note where
WP 37555, right?
37
You are referring to the same, we believe.
37599. Identical facts.
Ask him that it says.
Sir, your note says it is, you're referring to
3755. Your launch may take that minute. Page numbers would be a little different. That's
No. See the note which you have given.
That's too much. That's too much. Both the numbers should have input, but there's only one number that's.
No, so what is it? I'm like, short, what should, ask me, what should I take?
No, your launch may take 37555 only.
Asking to take 37555 counter. Of R5.
I had 2 minutes to file a vacate.
Yeah. What? Counter means vacate petition.
Along with the vacate petition.
Three seven triple five, Mister. Three seven triple five.
Page 82. This is the direction issued by the Power Systems Operation Limited.
Not that is given by the petitioners. This by R5. What R5 is the counter affidavit. Counter affidavit filed by respondent number 5. Ye two filed by Vichyasagar Bhav, Telangana, counter filed by R5. No one. There's some. You are referring to counter affidavit filed on behalf of R5 in WP 37555, correct?
Yes.
We are getting another copy. It's not there. Do you have a spare set?
They passed on a copy.
Probably from 78 earlier, 37599, that is 7879.
నేను చెప్తున్నాను కదా
37555 is the reference. Why? Yes. Yes.
No, this is issued by Power Systems Corporation of India, Government of India Enterprise.
Eighteen 2014.
Yes, 18/6/2014. And it subject reads the allocation of power to Telangana discoms from generating stations located in AP regarding. Lordship. This has reference, Lordship Sada. This has reference to fax communication dated 18/6/14 regarding reallocation and rescheduling of power from AP Genco stations located in the state of Andhra Pradesh to discoms in AP only. It is understood that YD GOMS 20 dated 8/5/2014 with GOMS 53, which deal with the specific allocation of power with effect from 9/5/2014. The proportion of shares have been allocated under PPA or otherwise, and they stand entirely allocated and transferred to AP discoms in fixed ratio. In this connection, attention is drawn to the minutes of the meeting on 28/3/14 of the task force committee constituted for the purpose of finalizing the share of Telangana and AP from the shared projects of each state to other states. In this meeting, the scheduling procedure was deliberated and consulted by all the task force committee members, including AP. Telangana. Accordingly, the scheduling procedures have been followed on the first day of formation of separate states of Telangana and AP. Therefore, the letter of the government of AP referred to above has to be in consonance with the decisions taken in terms of provisions of AP Reorganization Act. Therefore, AP SLDC is requested to take up this matter with the government of Andhra Pradesh to seek necessary clarification from the Ministry of Power, Government of India, which is responsible for giving bifurcation guidelines. Accordingly, APSLDC is advised to continue, Lodge may note that, is advised to continue with the existing scheduling procedure as in force on 2/6/2014 in conformance with the AP Reorganization Act until such time the clarification is obtained from the Ministry of Power. The matter may be expedited and avoiding operation difficulty. But pursuant to this direction issued by this corporation, POSOCO, there was no discontinuance of power at any, not even for a minute. On 18/6, we informed Muller that we are going to discontinue. On 18/6, the POSOCO passed an order, directed us to continue with the same scheduling procedure. We continued with the same scheduling procedure. There was no discontinuance of power as not to be contended by the learned petitioner, by the learned senior counsel for the petitioner. That there was discontinuance, therefore they had to purchase power from outside sources at exorbitant rate. And they had to pay, they had incurred an expenditure of some 4,000 and odd crore, which is nowhere mentioned in the affidavit filed in support of the writ petition. But this fact is not alleged anywhere in the affidavit. This direction was followed. This direction was followed by the Southern Regional Power Coordination Committee, which is again a statutory body under Section 28 of the Electricity Act. On 24/6/14, all central utilities like Southern Regional Load Dispatch Center, National Load Dispatch Center, Central Electricity Authority, and Southern Regional Power Coordination Committee, SRPC's Southern Regional Power Coordination Committee, along with TP Transco, taken a decision to schedule power supply from AP Genco to TS Discoms, even though AP Transco opposed the above decision, till receipt of directives or orders from the appropriate authorities. So there was another statutory direction 24/6/2014 that we shall continue with the existing system. Both are done, your Lordship may note one fact in the context whether the central government has the jurisdiction to issue the order impugned to the writ petition. Both these are the statutory bodies created by the electricity under the Electricity Act. Dealing with chapter dealing with interstate transmission. But they both have the power and jurisdiction to issue such direction to save the grid. But if I suddenly withdraw from supplying power, the grid is likely to collapse. If I start supplying to Telangana, the grid will collapse. It has become on 2/6/2014, on and from 2/6/14. The transmission became an interstate transmission. Therefore, the jurisdiction of these two bodies is vested in those two bodies. Then On 1/7/2014, Government of India constituted a under the chairmanship of CEA, constituted a committee called Neeraj Mathur Committee with POSOCO, that's the Power Systems Operation Corporation, PGCIL, Secretaries of Energy of Government of the AP, Government of TS to resolve power issues between AP and TS, including the PPS. This is mirrored on 7/1/7, immediately afterwards. As per Schedule 12 of APRA, Government of AP constituted a new regulatory commission on 1/8/14 while the GOMS 35 as per Section 82 of the Electricity Act, read with Section so and so, so and so. When it's Schedule 12 of the Electricity Act, may I invite your Lordship's attention to Section 12 of the Electricity Act, Schedule 12 of the Electricity Act. Reorganization, which enables the
Reorganization Act. That also you keep it no harm, keeping the book here. Hey, Mister, that
If your Lordships have the same.
one ALD you have brought, where 2015. No. We had told you to keep ALD available from 2000 till 2023. Done? Not done. We are in the court hall. Huh? Okay. Yes.
Lordships have the same book, it's at page 119. Schedule 12. There are three months. The existing APERC, Electricity Regulatory Commission, shall function as a Schedule 12, Schedule 12 of Reorganization Act. minutes. C minute deals with power. This schedule is under section 92 of the Act. 92 contemplates mirrors the central government to issue directions from time to time. 92 reads like this: the principles, guidelines, directions, and orders issued by the central government on and from the appointed day on matters relating to coal, oil, and natural gas and power generation, transmission, and distribution, as enumerated in the 12th schedule, be implemented by the successor states. The central government is empowered under section 92 to give directions. Schedule 12 deals with what are the aspects on which directions can be given. 3 deals with existing Andhra Pradesh Electricity Regulatory Commission shall function as a joint regulatory body for a period not exceeding 6 months, within which the separate SCRCs will be formed in the successor states. Therefore, while my application for withdrawal from PPAs was pending before the joint SCRC, which became APRC became joint SCRC with effect from notified date. AP government constituted a separate SCRC on 1/8/2014. GOMS number 35. But therefore, there was no joint TRC in existence at all. Why I am pointing out to you, Lordships, this is our application before the joint TRC, which was filed for withdrawing from the PPAs, was rejected in the strongest of the possible terms by the giant TRC, which was not in existence. But giant TRC order is dated minutes. Minute, I'll just give lots of the date. Minute on 11/8/2014. Lots may note this date. By which date, minute, the State Electricity Regulatory Commission of AP has come into existence with effect from 1/8/2014. The giant TRC minute ceased to have any jurisdiction or authority. Nonetheless, minute, the giant TRC issues an order on 18/4/2000, minute 11/8/2014, castigating minute the AP Genpos from seeking to withdraw from the PPS. And that is sought to be relied on by the Land Council for the petitioner. Then one more condition that was advanced is no power is given from Krishnapatnam Thermal Power Station. Krishnapatnam Thermal Power Station. Your Lordship, have a look at item number 10 in the list of dates. 18/4/2015, CMD Transco, TS Transco, orders a letter to SRRDC not to schedule power from APPDCL, that is Krishnapatnam Thermal Power Station. On another contention is that we did not schedule power from this thermal power station. They themselves are rather than
not, Mr. Senior Counsel, we will not go into this question. Which power plant you will supply? You supplied to them, Krishnapatnam or Patnam. This is not this. This is only relevant. The under challenges section 92 order. Challenge. He said that, as we remember, we don't have this, but broadly, which we can remember instances, that order has been passed without hearing. Section 92 does not permit this thing, central government to pass such an order. And this thing, it cannot be like the dispute between the distribution and generation company has to be adjudicated by an independent forum under the Electricity Act. All these are the contentions raised. We don't see how does it help you further your case.
Well, these facts are necessary to understand, because in the entire writ petition, they have suppressed material facts relating to by a subcommittee constituted by Ministry of Home, where they agreed that this is the amount payable.
So then you tell us that I am telling these facts in the context of their admission. Otherwise, see, out of context, we don't get anything.
So these are in the context of what they have alleged in their affidavit.
So you say that
these are
what we would have appreciated that first submission is that order is based on their consent, it's an admitted liability. Then you would have told the facts. We would have.
I will be arguing in thin air, in the light of the fact that.
All right, please go ahead.
And senior counsel argued for 2 days.
No, we will grant you 4 days. Don't worry.
No, I don't want 2 days. I would like to finish it today.
There's no problem.
No, I don't. I really don't. That's why,
No, we believe in a debate, right, on the issue. That's why we are. Otherwise, we can sit silently and hear you. That's another option.
Going to the debate, I need to give certain factual background. Otherwise, the debate has to
the scope, according to us, is confined to validity of an order passed under Section 92 of the Reorganization Act. We want to assure you that we will not adjudicate which thermal plant you supplied power, how much power you supplied, whether this thing happened, that thing happened, whether they purchased, you did not supply, therefore they purchased power from the market at a excessive, exorbitant rate. This is all beyond scope of the petition, according to us.
What your lordships are observing is true. But then since these facts are narrated in the affidavit and I thought I need to meet them.
Yes.
Well, these are factual aspects if I don't meet them.
Yes, please go ahead.
Your lordships will notice one fact that...
Please ask your juniors to give it in bold letters, right? Bigger this thing, small... six this thing, pages.
Right? So,
Instead of 3 pages, make it 6 pages.
yes, ma'am.
As it is, you are not this thing. Go ahead, please. So it will be easier for us to read.
But if it's
Bigger font, bigger font.
but I'm sorry for the
Yes.
for the inconvenience caused to your lordships. But I'll ensure that your lordships will get it in a bold letters.
Not bold, bigger font, bigger font. Letter.
Bigger font.
Yeah. Font.
That's
Letter so that it is readable. All these things are compressed. You also must be finding it difficult to read.
Since I've read twice or thrice, but I don't find it difficult.
You people are unique, Mister. We have
I've already read it twice or thrice. I don't find it.
We are finding it difficult.
But
Please go ahead. Please go ahead. Sorry for interrupting you. Please go ahead.
Then, your lordship may go to item 11. Chief Secretary's meeting was held on, and it was decided to release 150 crores per month towards arrears to AP Genco by TS discounts. Besides clearing the monthly bills, due to short payment by discounts for power supplied from 2/6/2014 to 30/10/2015, the dues had accumulated to 1,033 crores. Both the chief secretaries agree that the Telangana will pay 150 crores every month, but this amount was never paid. APRC approved tariff fighting OP number so and so for control period 2014 to 19 for the power supplied from AP Genco to stations to DISCOM for supply period. TS DISCOMs participated in the hearings. There is no dispute regarding the tariff. So far as tariff is concerned, there is no dispute. Then your lordship may go to the most crucial aspects, will come here. At a meeting held of SRPC, a joint meeting of Hyderabad TS discounts acknowledged the dues to AP Genco. May I just pass on a copy of this for your lord. The minutes of the meeting where the bills are accepted and the amounts were also
No, please file it along with the memo.
We'll do that. I'll do that. Since the learned senior counsel passed on some documents, I also thought I could pass on this.
No, we'll not. We don't remember which documents he has passed on.
He passed on the order passed by the TSHC, and then another order passed by another organization, which were not filed along with the count. A writ petition or not with the.
You have been supplied with the documents.
Anyway, I'll ensure that they are filed. The lords may note this date on 26/10/2016.
No, you give it to us like that.
Yes.
There has to be parity, otherwise there will be violation of Article 14. Normally we
I will not comply.
Yes.
This court is the repository of Article 14. I will not comply.
No, you told us so that it was done by him, so I should also be permitted. Do it. Yes. Yes. You have got this copy of the order, this meeting.
The lordship may go to page 3, page for last current page. Member Secretary SRPC stated that smooth operation of grid with proper accounting was that we lordships can skip that. Direct Finance AP Genco requested Telangana to release some due amount as an interim measure without prejudice to the outcome of various other issues on account of the huge outstanding amount of discounts. In TS discounts, AP Genco was unable to make payments to both companies. Last but one, it's at the top it is numbered as 111, 112, 111, and then 111. I'm reading the last paragraph on 111. The Director of Finance AP Genco requested Telangana to release some due amount as an interim measure without prejudice to the outcome of various other issues on account of the huge outstanding amount from TS discount. AP Genco was unable to make payments to coal companies, Mrs. SCCL, had stopped coal supply from 6th October 2016 and coal stock positions also had considerably come down to about 7 days. SA to JMD Transco stated this was a multi-level issue and had to be resolved at the state level. However, he admitted that the dues were there as per the decision taken earlier high-level meeting. They were releasing about 90 to 100 crores per month after adjusting payable to AP discount, by AP discount. He further assured that he would convey the request of the forum zones. Functional requirements of generation, coal supply was immediately required. MDJMD stated this is no decision is taken by the forum. But here, they agree that they will have to pay in accordance with the bills for the power supply from 2614. The last payment was received. Item number 15 on 21/4/2017. That's an amount of 50 crores. By then, there was already a queue of the monthly tariff payable of 200 crores. An amount due was almost about 1,000 and odd crores. Only this amount was paid. Then the 25/5/17 Genco issued notices. Then APSLDC issued notice to TSHC for stoppage of power. Then both of them stopped supplying power to each other 10/6/2017. Lord Mayor will get that at 20 minutes. Here I have given the total figures. This figure is never disputed, either in the affidavit, total amount filed in support of the repetition, or before the committee is constituted by the Union of India before issuing the impugned order. 3,441.78 crores. This is the amount, this. You will get the note, this figure was accepted by both the CMDs. Item 38 at page 70, 170, you should get that. Page 173 of this paper book. 19/8/2019. Lodgement go to page exhibit P9 filed by the petitioner along with the repetition. Once again, Lordships have 37555 page along with the repetition it's filed.
Exhibit P9.
Yes, P9.
Yeah, looking at this, no.
In other repetition, page 170, you lost.
Page 170.
Lordships have that.
The same thing.
AP representation, so and so is Energy Secretary, except all the 6 persons, and TD representation, except show Special Chief Secretary, and CMD TS Genco, etc. Your Lordship will go to the statement next. First item, AP Genco power bills. Both agreed. Will Lordships have that?
Yes. 174.
Will Lordships have that? First item mirrored AP Genco power bills. Amount due by AP 8,099.59 crores. Amount due by TS 11,641 crores. Correct. 11,641 minus 8,199 comes to 3,441 crores. Then mirror the interest. Interest on sales of power due to AP Genco, second item. Both agreed. That's 604, 4.70. Items 1 and 2 mirrored in the tabular statement. Mirrored the rest of the items pertain to bifurcation, demerger issues. Items 3 onwards mirrored. All other items till 29 on the next page. They pertain to demerger issues. Even then, mirrored, if the total amount is taken into consideration, your Lordships will find mirrored from Andhra Pradesh due is 1,106, 10,160. Amount due from Telangana is 12,648. Yet to be reconciled is 4,609. So much is the whole contention that an amount of 15,000 crores is due out of demerger. Therefore, we are not liable to pay this amount, which is a post-merger liability on Telangana government. Falls to ground. Well, this is an admitted amount by the Secretary Energy of the state and Mirrored exceptional Special Chief Secretary of Telangana. Now, Mirrored, what happened before the central government would be the question before your Lordships. Well, there is no dispute, Mirrored, even in the entire affidavit without fear of contradiction. Mirrored, they have not disputed the total amount due towards the power bills. In the reply filed, Mirrored, to the counter affidavit where it is contained on behalf of respond number 5, that this amount is not disputed anywhere. They say that the interest is not reconciled, properly reconciled. They don't come out with any figure. From this submitted figure, comes 3,441 crores. How do I realize this? There is a mechanism provided under Section 92 of the Act. Under Section 92, I was given a direction restricting the provisions of Electricity Act. Therefore, the state of Telangana, state of Andhra Pradesh Fed, this Union of India has an obligation, a statutory obligation and a moral obligation, legal obligation to ensure that this amount is paid to me. Not to link the demerger payments, liabilities of both the states, which are not been so far crystallized. They claim 15,000 crores, I claim 17,000 crores, they claim 20,000, I claim 25,000. But they have not been crystallized. This is a crystallized amount for the power supplied by AP state utilities. Therefore, we addressed the letter on 19/9/2007 for settlement of dues to the government of India. Well, the Dheeraj Mathur committee, which was constituted for the purpose of deciding power utilities issue, submitted its report and sent 5 reminders to Telangana state to sign and send the report back. They refused to sign. Therefore, the Union of India decides to disband that committee. Then AP Genco filed a petition before NCLT Hyderabad for regularizing the dues from TS discoms. This is on 8/1/2018. But due to non-payment of this amount, AP Genco became a non-performing asset. And notices were given for winding up of that company. The NCLT was moved by AP Genco for realization of this amount. Subsequently, it was withdrawn. That's on 3/9/2021 with liberty to approach appropriate forum. Then a writ petition was filed on the file of this honorable court on 7/9/2021 for a mandamus to direct the government of Telangana to pay this amount. On 8/11/2021, Government of India in the Power Ministry conducted a meeting. This is crucial, whether their contention that they were never put on notice is correct or not. On 8/11/2021, on the basis of the letter written by the Power Minister of State of AP and the Chief Minister, Minister of Power Constituted, you will not try to get this minutes of the meetings. May I just pass on that note 5 from which my the line minute also pay. This is part of the note file that the Central Government Council has produced before Lordships. Your Lordships will find that in the note file. Furnish me a copy of. There is a reference to this meeting in the note file. The brief background in Lordships will get all the facts that I've narrated. Lordship will go to the next page. They wanted this dispute to be linked up to Godavari water disputes. Tribunal. On the next page, item number 6. Lordship will see the stand of the Telangana government. They have somehow never wanted to pay the money. Then your Lordship may go to the next person. Next page. This is 11th November 2021 meeting. The It's addressed to Srikanth Secretary, Government of Andhra Pradesh, Sunil Sharma, Special Chief Secretary, Energy, Government of Andhra Pradesh, CMD Posogbo, COO, Central Transmission. I am directed to forward herewith the minutes of the meeting chaired by Secretary at 3:30 p.m. on 8/11/21 on non-payment of power dues of 6,101.88 crore by Government of Telangana Power Discom and to resolve the issues relating to post-bifurcation after Andhra Pradesh Reorganization under the Andhra Pradesh Reorganization Act for Information Necessary Act. Let's go to the next page. A meeting was chaired by Secretary Power on 8/11/2021 on the issue of non-payment of dues of around 6,101 crores to be paid by the power utilities of Telangana to Andhra Pradesh. The following emerged after deliberations during the meeting. There is no dispute, Your Lordship may note that there is no dispute of the principal amount to be paid for the power supplied by the Andhra Pradesh to Telangana. However, some reconciliation is required on the interest to be paid on the principal amount by Andhra Pradesh and Telangana. Both the state agreed to reconcile the figure as per the terms and conditions of the power purchase agreement. Andhra Pradesh representative said Telangana was initially paying the bills for power supply, but later on stopped paying. As the payment has not been received from Telangana, Andhra Pradesh has filed a petition before the Honorable High Court of Telangana, and Telangana informed that they would be filing their counter affidavit shortly. Telangana has claimed certain amounts to be paid. Telangana has claimed that certain amounts to be paid by Andhra Pradesh on account of issues related to the outcome of demerger of three power utilities affected by bifurcation. Telangana representatives committed to pay the net amount, if any, after incorporating demerger related issues. In Lordship may see, they again bring in demerger issues related to dues and remaining dues of power supplied by them. Sheila BTA committee has dealt with all the demerger issues and have given their recommendations. However, both Andhra and Telangana have not issued the orders as per the recommendation. Meanwhile, both the states have jointly scrutinized various demerger related. Rest of it is not necessary. Just pointing out in class one of these minutes, there is no dispute with respect to the principal payable. It was agreed by the representatives of Telangana. They had a meeting in the Ministry of Power, in a committee chaired by the Secretary Minute Power. If you got the note file that was passed on to your Lordship. Well, what was given by the Central Union of India for your Lordship's perusal? Your Lordships, look at page 4, paragraph 6. Of the note file, which is your Lordship's copy of the note file by the standing Government of India representative.
Photocopy was also given, no? Photocopy was also given.
Next paragraph 5 and 6 of the note file. Post bifurcation, Telangana had been paying the power they had been purchasing from Andhra Pradesh, but subsequent, your Lordships have that? Page 4/1, paragraph 5. Post bifurcation, Telangana had been paying the power they had been purchasing from Andhra Pradesh, Subsequently, they have not paid against the power purchase. During the meeting taken by the power on 8/11/2021, which minutes I read to you lots just now. Also, Telangana confirmed that they don't have any dispute with reference to the principal amount of the bills. However, only some reconciliation is required with respect to the interest payable on the outstanding dues, to which both the states agreed to resolve themselves based on the terms of the PPA. Hence, in a matter which is post bifurcation, and the matter is to be settled among themselves under the terms and conditions of the PPA. Meanwhile, it also emerged that during the meeting taken by the Secretary, that Andhra Pradesh has already approached the High Court. 10 minutes, as per Class C2 of Schedule 12, existing PPAs continued with the respective DISCOM. However, from the date of bifurcation of the states as per the agreement between the AP and Telangana, the power was supplied by AP to Telangana. It's also been established that during the meeting chaired by so-and-so, with the representatives of Andhra Pradesh and Telangana, that power was supplied by AP Genco to Telangana as per the agreement between the bifurcation states from the date of the merger, which is a post-bifurcation. I will not trouble you lots with the note 5 further. But at 8/11/2009, 2001 meeting minute I passed on to you lots of the minute the original is available with the central government in their file. No, when the government of India also constituted a subcommittee for resolving the dispute, minute on 8/2/2022. Lakshmi, I will look at my paper book. Constitution of the subcommittee. Minute, while the power ministry minute, a meeting was held and it was page 96. Exhibit R54A. This was minute the date on which page 96 minute along with the counter.
96. We'll do one page. That you keep it aside every time speaking from place. We are only dealing with using interface by computer. No, this is read. Yes, given. No. Getting books on that. This is see here.
Well, this is the office memorandum by which subcommittee was appointed to resolve bilateral issue. Page 96, dated 8 February 2022. Then your lordship will go to page 101, minutes of the meeting, summary of discussions. It is an enclosure to a communication dated 25/3/2022, which your lordships will find at page 100. Copy of the minutes of the dispute resolution subcommittee meeting held on 17/2/2022 to discuss bilateral issues between AP and Telangana received from Government of India, widely referenced second cited, is herewith communicated to the Special Chief Secretary. Lordships have that. 10 minutes, 101. Payment of power dues, views of Telangana. Representatives of Telangana stated from the very beginning that they are willing to settle the issue and made some progress. But also AP utilities went to NCLT. Subsequently, they went to the case from NCLT, filed in petition, which is sub judice. In fact, Telangana has no dispute regarding the amount of dues. Your lordship may note that. In fact, Telangana has no dispute regarding the amounts due. However, the amount receivable by Telangana should be taken into account while settling the dues. That's when a divergent dues, which are not fully quantified till now. But still, if the government of Andhra Pradesh is willing to settle out of court, government of Telangana is open for settlement. Government of Telangana reiterated that Parliament partial settlement of issue is not acceptable to them, and they will go by total settlement of the issue. Then when the views of minute line 3, minute line 4 in the under the heading views of Andhra Pradesh, it has to be dealing with other demerger issues of power utilities. Petition filed in the High Court of Telangana also does not come in the way of settlement of these power dues, keeping in view PPA direction. Further, there are not any orders by the High Court prohibiting any direction towards. Then views of the minister. At the bottom, there is the views of the Ministry of Power. Representative of Minister of Power informed that the matter has been referred to law on 3/2/2022. But this was pursuant to the meeting which I read, minutes of which I read to your lordship. 8/11/2021. 8/11/2021, where they had agreed that this is the amount due. So when the Ministry of Power had sent a note to the Law Ministry, to the Law Department, formulate its opinion. Can the order and section 22 be given for payment? Can the amount be deducted from the account of Telangana and be credited to the account of Andhra Pradesh? In conclusion, your lordship may note that Joint Secretary suggested that after getting the views of Ministry of Law, the Ministry of Power may communicate the same to both the state governments, and Ministry of Home Affairs for their comment. Further action will be taken on the issue based on the comments of both the state governments and the opinion of Ministry of Power. When the Ministry of Power, when the learned senior Ms. Vaidyanathan, when took your lordship to the note file, the file went at both minute, twice opinion was sought from the learned Solicitor General. Initially, learned Solicitor General said, minute in view of the writ petition pending filed by the AP government for recovery of this particular amount, the dues for the post bifurcation supply of power. It will be overreaching the court if an order is passed, an executive order is passed. Well, therefore, we withdrew that petition. After that, the file went back again to the learned Solicitor General. Last time, I'm not troubling your lordships with all that. The learned senior counsel took your lordship to that. In fact, learned senior counsel took your lordship to the draft started, had a comment to make on that about how the final order had changed, etc., etc. Second time, the opinion of the learned Solicitor General was that in view of the withdrawal of the writ petition, a direction can be issued under Section 19. This meeting was followed by another meeting of the same subcommittee before the order was issued. That's mirrored on 17th June 2022. Your lordship will find that at page.
115.
17/6/2020. That's page 115 minute. 117. 116, your lordships will get the communication. Lordship may go to 117. Here again, the admit period that there is no dispute in respect to the amount. Period on page 116 minute is the minutes of the meeting. Item A, payment of power dues to AP Genco by TS discoms. CMD Genco Transport reiterated that it has settled all the dues from AP power utilities.
So you're referring where 116 of your
bank? I've been referring only to 3755.
Yes, yes. Is it annexure 27?
Yes, my lord, annexure 27. Annexure 27 is the communication attaching the minutes. Minutes your lordships will find on 117.
1811.
Lordships have that. Payment of power dues to AP Genco by TS discoms. Views of Telangana, CMD, TS Genco and TS Transco reiterated that if they settle all the dues from AP power utilities, your lordship will note that. If they settle all dues from AP power utilities, they have to get more than 12,500 crores from Andhra Pradesh. He informed that they have come to know last week only that AP Genco has withdrawn the writ petition filed in the High Court. Government of Telangana contested the withdrawal of writ petition by the government of Andhra Pradesh. Subsequently, 2 writ petitions have been filed by TS Genco and TS Discom in the High Court of Telangana a few days back, and it is sub judice now. But pausing here for a minute, what we sought in our writ petition we withdrew was, this particular amount of 6,114 crores, principal being 3,441, and the balance being the surcharge, is an admitted amount. Once the Minister of Power felt that there is a writ of mandamus pending before this court and they can't do anything in the matter, we withdrew it. That matter file went back and forth, and ultimately a decision was taken. Before a decision was taken, another meeting was held by the Ministry of Home. There the stand is, unless the demerger issues are settled, post-merger liabilities cannot be taken up by the government. Government of Telangana stated that the TS entities have been put to more hardship than US entities. First, cancellation of PPAs by Andhra Pradesh. Secondly, Telangana is not getting much power from Tungabhadra project. Finally, use of Andhra Pradesh. Principal Secretary Finance stated that AP power utilities are suffering due to huge amount of power dues pending from DISCOM against the power supply at the directions of Government of India. Therefore, prolonging the matter at this would not be very fair and tenable, and MHA should intervene in the matter. Views of the Ministry of Power, Lordship may note that that's important. Chief Engineer, Ministry of Power stated that after the withdrawal of the case by Andhra Pradesh, they are trying to settle out the dues that are being claimed by both the state governments. After that, the Minister of Power may issue an order under Section 92 of the Act directing the amount payable by one state to another in whatever process the Minister of Power finds it suitable. It can be through the devolution of central funds, central payments to the state governments. Our Minister of Power stated that they are unaware about the filing of the 2 writ petitions by the government. Let your Lordship see the decision taken. MHA will be taking up the matter with the Minister of Power and Minister of Law for their comments and decide further course of action. But it is pursuant to these meetings that the impugned order was issued, directing payment of this amount. One meeting where both the representatives were present held by the Ministry of Power on 18/11/2021, 8/11/2021. One meeting under the aegis of the Minister of Home Affairs on 2/6/2022, 17/6/2022, and a third meeting by MHA. No, first 17 2 minutes. I'm sorry, minutes. MHA meeting was, first meeting was 17-2. Second meeting was on 17-6. In all the three meetings, your lordships would find one thread running through. One is that they don't deny the liability. Second is they want the Union of India to link up demerger with the post-merger, post-merger dues. Demerger issues arise out of the common funds that were collected by the then erstwhile government of Andhra Pradesh and spent on establishing certain institutions. And demerger issues are not crystallized so far. Whereas this amount is accepted by both the parties, at least the contesting party. In their entire affidavit, they have not disputed the amount, filed in support of the writ petition. Now, to contend that, or for the TS utilities or the TS government to contend that unless demerger issues are resolved, but one aspect on which none of these meetings, none of these admissions made before the committees, high court committees, find a place in the affidavit filed in support of the in both the writ petition. None minutes, not even one reference to any one of these meetings. Either 18/11/2021, 8/11/2021 or 17/2 or 17/6. They don't even refer minutes, they completely ignore them, suppress them, and go on to contend that there is violation of principles of natural justice. In my submission, suppression of these events that have taken place, or the meetings that have taken place, including the order of Osako, which directed the TS utilities to schedule the power as it was prior to bifurcation, that is also suppressed. When the writ affidavit, when the writ petition, suppression of these material facts to establish that the petitions have not come with clean hands. Firstly, there is no violation of principles of natural justice in view of the facts are submitted and the documents are filed along with the counter. Which documents, are not denied by the respondent, by the petitioners in their reply. Second, there is no denial of their liability at all, the entire writ affidavit. Except one space sentence in the reply to my counter, where they say that the interest has not been reconciled. If you look at there, that's the reason why, with great respect to the learned senior counsel who appeared for Telangana State, he didn't even refer to my counter. He didn't want your lordships to look into the counter. But he just referred to the counter affidavit of the central government, two pages. They have nothing to lose. They don't have to state all these facts. And the note file, read only those portions of note file which are advantageous to him. Completely ignored paragraph 6 and 7 of page 4 of the note file. And this meeting held on 8/11/2011. And when it comes to my counter affidavit, I heard him say that their counter affidavit is not what the paper written, on which it is written. Because all these facts will come out. But in the reply affidavit, adjustment as to where there is a dispute. This is the only sentence in the entire pleadings in both the writ petitions. Page 15 of their reply, my lord, to my counter affidavit in WP number 37599. Madam, sorry, madam, I'm taking you lots. There are page 15, madam, you lodge may note the page number of in WP number in the reply filed in WP number 37599 of 2022. Except this sentence, madam, there is nothing else anywhere.
Reply. 37599. Reply.
Right. If Justice Shravan Kumar doesn't have it, I have a copy. I'll pass on. It's awesome. But at page 15, the entire affidavit deals with current demerger issues. They say that we want so much money, they are liable to pay so much money. The only place they deal with my contention with respect to a dispute regarding the quantum is this. Page 15, penultimate paragraph. No, just above the just above the unnumbered paragraph, fourth line. The interest portion cited, your lordships have that. The interest portion cited in the impugned order is not confirmed or reconciled by Telangana discoms. This is the only sentence. Now, coming to, since they have accepted their liability insofar as the power bills are concerned, the question that would arise as to how the surcharge is to be levied. One minute, the POSACO gave a direction. They directed us to continue with the PPS. When the PPS themselves, though were not approved, contemplated as to how the surcharge is to be calibrated. I filed this PPS, all the PPS, and your lordships will get that beginning at page 69, 555, 37555, page 69, R51. Lordships have it. Page 69 starts. Power purchase agreement between AP Power Generation Corporation and AP Distribution Companies. For the period from 1/4/2006 to 31/3/2019. Your lordships have seen the POSACO order says that continue with the power purchase agreement. Now your lordship may go to page 72. Page 72. In case of payment by discoms, sorry, APPDCC/AP discom is delayed beyond a period of 60 days from the date of billing, the late payment and late payment surcharge at the rate of 1.25% per month or per part thereof shall be levied by AP Genco. But this is a fixed figure. This power purchase agreement is on terms of the regulations framed by the APERC in Regulation 1 of 2008, which you lordships will find at page 132. This is a statutory regulation framed by the APERC, Reswell APERC, which is still continuing. There is no change in this. Lordship may go to 133. This mirrored Regulation 1 of 2008 is framed under Section 62, read with Section 68(1) of the Electricity Act. At page at 16.2. In case of payment of bills is delayed beyond, your lordships have that? In case of payment of bills is delayed beyond a period of 2 months from the date of billing, a late payment surcharge at the rate of 1.25% per month shall be allowed to be levied by the generating company. Therefore, the rate is fixed. The amount liable to be paid by the petitioner is accepted. The interest surcharge is fixed. Surcharge is also fixed now. Now your lordships are
We have another bench at 4:15, right? We just is Vinod Kumar. He's here, you know. Just Vinod Kumar is sitting. Ah, 4:15. This is Vinod Kumar is available today. Have you found out or just saying yes? Madam, Justice Vinod Kumar is available today, no? 4:15 we have another. So we'll continue. Sure.
Tomorrow.
Huh?
Tomorrow.
Tomorrow? You are a local council or?
I keep floating between here and Amaravati.
Acha, you are from Amaravati.
No, I'm not from Amaravati.
Okay.
I'm up here. I keep moving between Amaravati.
Tomorrow.
I thought I'll just finish these 2 minutes, 3 minutes. So that my
We have a special bench. That's why.
Sorry.
Otherwise, we would have heard you till 4:30 or even beyond that also. But we have a special bench.
I thought, since I am on tariff, I could complete the narration of that.
You should get equal time, mister. We will try our best to give equal time.
No, I'm not asking for equal time, I just want to submit my case, that's all.
No, you will have the opportunity.
God bless you.
from GP Singh's interpretation of statutes. At the bottom of page 36, seventh line from bottom. It has been so held in two Constitution bench decisions. The passing observation in these cases that Section 6 only applies to repeals and not to omissions needs reconsideration for omission of a provision. These are commentaries of Justice GP Singh. And they have been approved here in fiber. For omission of a provision results in abrogation or obliteration of that provision in the same way as it happens in repeal. The stress in these cases was on the question that a rule not being a central act or regulation as defined in the General Clauses Act, omission or repeal of a rule by another rule does not attract Section 6. Now kindly come to this is how they have killed the portion of Raila Corporation as per incurium because it is not forming part of the ratio. Here, in that context, my Lord may kindly see page 37. In view of what has been stated here and above, perhaps the appropriate course in the present case would have been to refer the aforesaid judgment to a larger bench, but we do not find the need to do so. That is because of this substitution, my Lord. Now, in my case, my Lord would appreciate there is absolutely no substitution. Where it is only an omission simpliciter, then nothing is saved. That is the repeated.
The book is there. Two books have come from
Yes.
interpretation and this book.
It's two judgments.
From residence, they have been saying. Residence. Justice GP Singh's book also must be there. Give it. And the other, that judgment. Corporation, this fiber board.
Fiber board.
Yes.
In this context only, my Lord may kindly recall, I have relied on this 257 ITR 338.
Omission of a provision results in abrogation or obliteration of that provision in the same way as it happens in repeal.
Yes, my Lord.
This is the opinion expressed by Justice GP Singh in his book that has been approved in fiber board.
Yes, I'm fully with that. Now, in fiber boards, when section 280 ZA was omitted, simultaneously section 54G was. Whereas
we have understood that.
Yes.
In your case, it's a case of omission simpliciter and not substitution.
Exactly. When in the absence of substitution, this omission.
The decision in the fiber board will not apply.
Exactly. Because there is no saving clause in the amending act. In fact, my Lord, I did some research into the memorandum explaining the provisions in the Finance Bill 2015 because this omission took place virtue of Finance Act 2015, though with effect from 2019 because the Gazette notification was dated later. Now in the memorandum also, there is absolutely no whisper. So the Parliament in its wisdom has omitted this provision. When they have omitted this provision, as pointed out in
book fiber boards.
Like.
We have understood.
No, I'm only continuing on the proposition.
Yes. Yes.
In that regard, I would rely on one more constitution bench decision.
State of Orissa.
Paragraph.
Which
21.
is here? Constitution bench.
This is on section 6 of General Process Act, when it is attracted. Paras 21 and 28. They repeal. Will not may kindly take paragraph 21. When there is a repeal of a statute accompanied by the enactment of a law on the same subject, the provisions of the new enactment would have to be looked into not for the purpose of ascertaining whether the consequences envisaged by section 6 of the General Process Act ensued or not. Section 6 would indeed be attracted unless the new legislation manifests a contrary intention, but only for the purpose of determining whether the provisions in the new statute indicate a different intention, referring to the way in which such incompatibility with the preservation of old rights and liabilities is to be ascertained. This court in state of Punjab versus Lord Singh said, such incompatibility would have to be ascertained. Such incompatibility would have to be ascertained from a consideration of all the relevant provisions of the new law, and the mere absence of a saving clause is by itself not material. The provisions of section 6 of General Process Act will apply to a case of repeal even if there is simultaneous enactment unless a contrary intention can be gathered from the new enactment. Of course, the consequences laid down in section 6 of the Act will apply only when a statute or regulation having the force of a statute is actually repealed. Now, kindly come to paragraph 28, my lord. A saving provision in a repealing statute is not exhaustive of the rights and obligations so saved or the rights that survive the repeal. It is observed by this court in IT commissioners. In other words, whatever rights are expressly saved by the savings provision stand saved. But that does not mean that rights which are not saved by the savings provision are extinguished or stand ipso facto terminated by the mere fact that a new statute repealing the old statute is enacted. Rights which are accrued or saved unless they are taken away expressly. Now, this is the principle behind section 6C of the General Process Act. We agree with the High Court that the scheme of 1973 Act does not manifest here also this was on Foreign Exchange Regulation Act. Does not manifest an intention contrary to and inconsistent with the saving of the repealed provisions of section 56. Now, 29 says, this takes us to the next question whether that is on the particular case. Now, there they have said, this has been further elaborated, my lord, in a series of judgments. Going by, before I take my last through one more judgment of the Honorable Supreme Court, may I draw my lord's kind attention to FEMA, section 45, not 45, section 49, repeal and saving.
Section
49, my lord. Subsection 3 and 4.
Yes.
Now, subsection 3 says, notwithstanding anything contained in any other law for the time being in force, no court shall take cognizance of an offence under the repealed act, and no adjudicating officer shall take notice of any contravention under section 51 of the repealed act after the expiry of period of 2 years from the date of commencement of this act. Again, subsection 4 says, subject to the provisions of subsection 3, all offences. Now, when we treat this omission at par with repeal, omission of subsection 3 of section 6, there should have been a saving clause to continue proceedings which were initiated during the currency of the section. In that context only, I relied on, because of the approved resolution plan, what are the after effects of, fallouts of the resolution plan. Will all may kindly see in the case law paper book at pages 57 to 99, I've given copy of the judgment. I would only trouble my lords for the conclusion at running page 87. This was also brought to the notice of the adjudicating authority. Conclusion in para 95 at running page 87, my lord. In the result, we answer the questions framed by us as under that once a resolution plan is duly approved by the adjudicating authority under subsection 1 of section 31, the claims as provided in the resolution plan shall stand frozen and will be binding on the corporate debtor and its employees, members, creditors, etc., and including the central government, any state government, or any local authority, guarantors, and other stakeholders. On the date of approval of resolution plan by the adjudicating authority, all such claims which are not a part of the resolution plan shall stand extinguished, and no person will be entitled to initiate or continue any proceedings. Now, by virtue of this, also, assuming for a moment this provision can be made use of without admitting. By virtue of this,
but this is not the point argued by you before.
No, this was also a ground I have taken before the single judge, learned single judge. This.
Yes.
This was the second ground I had taken before the learned single judge, and she did not deal with this ground at all in the impugned order. My lords would appreciate that in the impugned order by the adjudicating authority, may I draw my lord's kind attention. That is at page 69 to 110 in the writ appeal running page. I would draw my lord's kind attention to page 106, 107. But 107, there are 6.1. He had accepted. I hold the charges of contravention of the provisions of paragraph so and so paragraph. All these are in terms of section 6.3. By notice number 1. However, by virtue of order of Honorable NCLT Hyderabad dated 13th April 2018, I impose no penalty. Now, when no penalty is imposed on the main company, my humble submission to my lord says there cannot be fiction upon fiction. The doctrine of approbate and reprobate comes. It is a species of estoppel and it does not operate against law. because all these and interestingly, my lord, why he has not levied the penalty on the company? My lord may kindly take page 105. After that conclusion, in the that is the same paragraph 95 is reproduced here. My lord may kindly see in the conclusion, clause 3. Consequently, all the dues, including the statutory dues owed to the central government, any state government, or any local authority, if not part of the resolution plan, shall stand extinguished, and no proceedings in respect of such dues for the period prior to the date on which the adjudicating authority grants its approval under section 31 could be continued. Now he says, it's a very interesting thing, wherein Honorable FX Court has held that on the date of approval resolution plan by the adjudicating authority, all such claims which are not a part of resolution plan shall stand extinguished, and no person will be entitled to initiate or continue any proceedings in respect of a claim which is not part of the resolution plan. Now, the interesting statements come. The complainant department herein, enforcement directorate, was not before the adjudicating authority and IBC. Now, that is his own choice. But further he says, and even not part of resolution plan, in view of the above, by virtue of the fact that notice number 1 is no more at present. I do not know how he comes to that conclusion. The company continues and technically ceased to exist, which is wrong appreciation of fact and law. Any liability enhanced on the notice entity or on message so and so after the approval of the plan stand extinguished on its own. Now, how does it cease to exist, my lord? I am posing the question to myself. He says, on any other proceeding, that would also stand terminated. Presently, the notice number 1 herein has since technically died, which is totally a misconception of law, misinterpretation of the legal position.
These submissions will be available to you to be urged. We are not, in case we will examine only when we agree with you that you need not go to the remedy of appeal.
Because my basic submission is, there is no saving clause, it is simply cited. My lords have already noted, therefore I do not want to end that. I mean, after a long day, exhausting day for my lords.
Thank you.
I'm really obliged to. But here, the matter is that in this context only, I was relying on the 257 ITR 338. In the case of general finance, will not may kindly take the general finance company and another.
This is 2002 7 SEC 1.
I have given, yes, my lord, the same. Here they have said categorically, the last 2 paragraphs. Just like it fell from the bench that fiber boards is binding on the laws. This decision is also equally binding, and this is indistinguishable from the facts of my case. Whereas fiber boards, there was a saving clause. Fiber board, there was a saving clause. That is why all other decisions.
How much time you are likely to take more? It then assemble tomorrow then.
Tomorrow, what time?
Same time.
Ask me lot pieces. Because I may take little. I mean, I was really, in fact, reticent to make a mention in the beginning because I find the lords got exhausted. I was sitting in the court. Same time,
it's part of our job. Nothing to We are only asking you how much time will you take more?
At least half an hour, at least.
We thought that you have given a note and everything.
No, I try to be as brief as possible.
Learned senior
But if I can reduce it to 15 minutes.
The petitioner commenced his submissions, however, on account of paucity of time, the same could not be concluded.